All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit admonished to draw nigh and give their attention. For the court is now sitting. God save the United States and this honorable court.
Be seated. I want to welcome everyone to the Fourth Circuit Court of Appeals this morning and to this magnificent courtroom. We look forward to 4 interesting cases with a group of outstanding lawyers. And with that said, we'll call the first case, which is United States versus Tressman. And Mr. Blau?
Yes, sir, Your Honor.
Good to have you with us, sir.
Thank you, Your Honor. Good morning. May it please the court. My name is Dan Blau. I'm with the Blau Law Firm in Raleigh. It's a pleasure to be with the court this morning to speak with you about Alex Tressman. Your Honors, police frequently come into contact with vehicles that might be considered abandoned under local ordinances. But that does not mean that the officers can then in turn abandon the Fourth Amendment when they're trying to figure out how to deal with those vehicles. But the officers in this case did just that. They committed 2 separate Fourth Amendment violations related to Mr. Tressman's van. First, they entered and searched his van without a warrant in order to address a medical emergency that did not exist. Second, they impounded and inventoried his van without complying with their internal regulations and local code as a pretext to search for evidence of crime. And for either or both of those reasons, this court should reverse the district court's order denying Mr. Tressman's motion to suppress. I'll first take up the initial entry into the van, which was due to this purported medical emergency. We're dealing here with the emergency doctrine, which is an exception to the warrant requirement. It allows police to make entry into a particular area to render aid to someone who's experiencing a medical emergency.
What do you make of the fact that emergency is a vehicle when almost all of our case concerns have been about the home, which is different, but don't we have some unique facts here? We got an abandoned vehicle on private property with evidence that someone was living in this van. They come upon it, and it's rather unusual. It's got this air conditioning unit, as I understand, but it's not functioning. Wouldn't it seem prudent to take a look into this van that's sitting out in the parking lot, and it looks like someone lives in it, and it's just there?
Well, Your Honor, here's what I believe would have been prudent, and I think this is a situation that we could all put ourselves in. We've probably been in this situation many times in our lives. Say you're at a restaurant and you come to a bathroom door and you don't know if anybody's there. You don't just open the door and go in. What do? Hi, anyone in there? And you knock and you try to figure out if someone is there.
And here you have to add a couple additional facts too. It's a bank parking lot.
Yes, sir.
It apparently was there in the morning when the bank opened. And if you looked in the front window of the van, there's some heavy-duty guns in there.
Yes, sir.
Including an AK-47 or an AR-15 or something, an assault rifle.
Right.
And you can't see in the back. Go ahead.
Well, I think there are 2 separate issues. The first one issue, which is kind of the second Fourth Amendment issue in the case, is whether the police could impound and inventory the van to deal with the situation of the firearms being in.
I think this ties in with the medical emergency too. You brought up this bathroom business, but this is not a restroom.
Right.
And you go knock on the door. This is a van that looks like someone lives in it. You look in it and you see these assault weapons in plain view. And you have to believe no one has left a vehicle out in the middle of a parking lot like this with plain view weapons in it unless they're in it. I mean, you would think someone is in this van because you don't just leave that out in the parking lot and ultimately you discover that the door is actually open, but I guess that wasn't part of it. That's not part of this, but it's a strange situation at the very least, isn't it?
Well, I think what's strange, Your Honor.
California plates on it?
I'm sorry?
And they had California license plates.
Yes, sir.
And it's in the Fifth Third Bank lot at Kannapolis, North Carolina.
Yes, sir.
And they had trouble running it down.
Right.
In the records.
Well,
I mean, and Judge Osteen, who's an able and experienced fella, gave you a 2 or 3 day hearing on this thing.
Yes, sir.
And let's be sure, you said no one called out, but that back door was ajar, wasn't it?
Well,
The
if you're on,
officers opened it and they called out to see if anyone,
well, let's
at
look to
least that's
see.
what they testified to.
Yes, sir. If your honors have the joint appendix in front of you, on page 35, you can see a good picture of what this ajar door actually looked like. And it is, from the picture in the joint appendix, this was from the government's response to the motion to suppress, it is not apparent at all that that door was ajar. Now, Judge Osteen did credit the officer's testimony that perhaps the strips didn't line up correctly and they thought there might have been an issue there. But
He credited the officers, all the officers' evidence. So he accepted what they said.
well, he accepted it, but of course, when we apply the test for the emergency doctrine, the question is not what the officer's subjective intentions are.
And what is this, like a subpart of the emergency doctrine, what do they call it, the community caretaker?
Well, that is separate and
that
apart.
different?
That is separate and apart.
Related to it, isn't it?
Well, this court has said they may have similar underpinnings, but they are different. The community caretaking exception comes into play when officers are encountering vehicles that have been in accidents or blocking traffic or things of that nature. This court says that we need to apply a different test when we're dealing with a medical emergency situation because that's actually falling under the exigent
They
circumstances.
didn't know it was a medical emergency situation. They thought it could be.
Exactly. And if we
It could be
look,
someone in there asleep or dead. I think Judge Osteen said that.
exactly. And Your Honor, if we look at
No.
if we look, exactly, we don't know. And if we look,
act. I mean, this is a pretty classic example, I think, of officers being reasonable.
I think this court's test is significantly higher than what Your Honor has just described.
They have to be reasonable. That's what the Fourth Amendment says.
Yes, sir. If you look at the Moss case from this court says that officers need to have evidence that an emergency existed that required immediate entry. So not just that it's possible.
Counsel, don't we, I mean, we're just kind of talking about these facts as if we're looking at this case de novo a little bit. And it seems to me it's important that we're reviewing the denial of a motion to suppress.
Right.
And in that circumstance, what we do is we look and see if there's clear error in the district court's factual findings.
Right.
And we construe the evidence in the light most favorable to the government.
Right.
And then we see if, effectively not just that you could have come down differently, but that the record compels the opposite result. And I can appreciate some, good arguments that I saw you made below and made in your briefs that maybe this wasn't objectively reasonable. But the district court listed 7 or 8 facts in the record. So it wasn't like it was not factual support. So how do you deal with, even if I accept that you could look at this 2 different ways, maybe it's objectively reasonable, maybe it's not, doesn't our standard review put us in a situation where, we just really need to see if there's facts that support this conclusion from the district court?
Well, and I don't know that the facts are in great dispute in this case. There doesn't seem to be a whole lot of difference between ourselves and the government about what actually happened. But this court can certainly reviews de novo the district court's conclusion about whether those facts created a reasonable belief that an emergency existed and that immediate entry was required.
That sums up your position here, just what you just said, that the judge was wrong.
Yes,
in
sir.
that conclusion.
That if you consider the facts that the court found, you still arrive at the conclusion that there was not sufficient evidence that an emergency existed that required immediate entry. If we look at the Moss case where the court sets out that test, this is the case where an officer comes upon a car that's parked on a service road in front of a cabin and is blocking traffic. And the officer thinks, well, that's unusual. Someone is, maybe inside this cabin. They may need medical assistance because they've left the car parked askew. And the officer goes inside the cabin to render assistance to someone that possibly could be inside. But as Your Honor indicated, as in this case, we don't know.
Speak to the second issue, the second question, whether the impounding is justified. You state in your reply brief that you do not necessarily dispute the officer's decision to
Yes, sir.
impound as to whether it was reasonable in the circumstances, but you take issues with how the officers conducted the search?
Well, I think we take issue with a few things, Your Honor. Officers
But not the decision to impound. You don't take issue with that.
Well, we have an impound and then we have an inventory. Those, I think, are two separate Fourth Amendment incidents. And when we look at them,
Don't they have to do an inventory when they impound? I mean, they go together.
they do not have to do an inventory when they impound. In fact, I think one of the troubling things in this case is that under the police guidelines, it gives them no criteria to exercise their discretion to determine whether to inventory. It says you may, but it doesn't require it. And that means that police officers could do it for any reason or for no reason, including for improper reasons.
What did they find in plain view? Tell me about those weapons. What was the weapons and stuff they saw when they looked in this van?
Right.
It's been sitting in a parking lot for how long?
Well, at least since the prior afternoon.
So how long? Day?
I don't think it was a day yet at that point, but it was
12, 14
18
hours.
to 18
California plates on
hours.
it, has a
Right.
air-conditioned unit on it. Looks like somebody could have lived there. Looks like it could be.
Right.
And you look in it, and what are those weapons that they saw in there?
Well, there's a rifle and there's a I think a handgun case.
There's an AR-15.
Yeah, right, a rifle. Yes, sir. Assault rifle.
But when they go in the back, I think, that's what I thought the question was. There's additional weapons there.
Right, and we contend that the secondary violation occurs before they go into the back. And
Were there weapons, more weapons than the AR-15 and visible in the front?
there was an AR-15, there was a case for a handgun. They didn't know if it contained a handgun or not. There's also what is a tannerite, which is something that's used on a shooting range that kind of makes an explosion, and I guess
There was bomb-making material.
Well-
And wasn't there ammunition?
There may have been a box of ammunition visible
You
in the
can
front.
see all that from the outside.
And it's not, and just to be clear, it's not our contention that the officers couldn't do something about this. The issue is that when the officers decide to act, you have to look to see if the primary motivation is an impound and inventory under their code, or if they have a motivation to look for evidence of crime. And here is where, even though perhaps they could have done a lawful impound, you have to look at how they actually did that to understand what their motivations are. And here we have
It just doesn't seem to follow right now. You see this vehicle out here, and you look in there, even before you go in the back, you see this AR-style firearm, ammunition, I think, some other items that are in plain view. What's this tannerite? What's that?
This is, and this is not my area of expertise, Your Honor,
That's the
but it's,
bomb-making material.
well, it was described in different ways, but I think in the parties agree that it's something that is used on shooting ranges where a person can shoot it and it makes an explosion. So it's I guess people who shoot at ranges may.
I mean, that's the legitimate use of it, but
Right.
it could have some other use
Well,
of it too.
I think anything
It's
can have.
sitting in the bank
Right.
parking lot. We haven't emphasized that either.
Well,
It's outside the bank.
Well, and again,
It's right outside the bank, and the bank people are the ones that called the police.
I don't disagree with anything the court's saying.
That's what we're getting at, is that if you don't disagree with what we're saying, you got a vehicle out there with all these weapons in it, you got tannerite in it, and you're saying these officers can impound this vehicle. You don't question that decision. It's the inventory. They can't look in this vehicle and see what's in it with this California plates in a parking lot?
Your Honors, you have to look at how they actually did this in order to see what their true motivations are. We have
They tried to call the owner several times. They could not locate the owner of it. They didn't just go and pull it in and start looking. They made some efforts to try to locate that owner. They went back and forth with the private property owner, the bank, several times, asking, what do you want to do? What do you want to do? Well, he made it clear he didn't want this thing on his property
Right.
at the time, but that's not dispositive. But
Right.
all these facts are here, and
And
it
this-
just seems like there are a lot of things we let officers do, but this looks like one of the things that ought to be pretty easy as to in terms of deciding.
Well, there are easy things, Your Honor. It's specified in their own regulations and in the city ordinance how they're supposed to deal with these situations. And those regulations and ordinances
We aren't
say.
bound by those, though, we aren't. We're reviewing it under the Fourth Amendment.
Well, that's true, but one of the.
That's a question of what they did was reasonable.
But this court has said, and this is from the Brown case, when we look at when an impound and inventory has to be reasonable, one of the factors that this court has instructed us to consider is whether the police have lawful custody of the vehicle and whether it's conducted pursuant to standard policies. So that is something that we have to look at here. It's not just about whether in theory they could impound it. Part of the reasonableness that
They have a policy that allows the inventory, and I mean, you quarrel that it's not specific enough, but it really doesn't say you got to do it 1, 2, 3, 4, 5. I know you have an argument that they should have been more, could have done it better, could have, listed out the guns separately or the cash, but they also, they didn't seize the potentially criminal evidence. They didn't do things that you would do if you were really conducting a criminal investigation, or at least that's what the district court found.
Well,
So once again, you got some facts that might support your position. You got some facts that go the other way.
Well, they took all the guns out and ran the serial numbers, and that kind of only tells you one thing. But I think the bigger problem here is that when we have a van on private property, there's a greater potential for abuse of the ability to impound an
They're on
inventory.
the bank property, aren't they? Right next door to the bank.
Yes, sir.
With an AK-47 or an AR-15
Yes, and
and ammunition and
And-
explosive material.
yes, sir.
That's the very exigent circumstances, but he didn't talk about that. But I think I'm surprised they waited as long as they did before they went into it.
And their city
There were
code.
some limitations here. I mean, the court didn't find this to be pretextual. Once they searched this area and saw the cash, they went and got a warrant. They didn't just keep on with an inventory search for the rest of the items that were in there, like the bomb-making books and all that kind of stuff, or the Trishman ID, or his IDs, anything like that. They didn't get that till after they got a warrant, did they?
No, but we contend the violations had already occurred at that point. See, my
They
time
did
is
get a warrant,
eventually.
and they got another warrant for his cell phone.
Eventually.
Based
Right.
on, right, there are two search warrants that ultimately, but you're trying to suppress this to help him with his conviction.
Well, we contend that the warrants they ultimately got, the information in there was all fruits of the two
Right,
Fourth
I
Amendment,
understand.
prior Fourth
Yeah,
Amendment
that
violations.
flows from that.
Right,
But
yes,
there
sir.
are two warrants involved.
Yes, sir.
The first part, there was no warrant.
Right, correct. Thank you, Your Honor.
Thank you, and you stayed a few minutes for rebuttal. And Mr. Green?
Good morning, Your Honors. My name is Graham Green. I represent the United States. As this court has, I think, addressed in its questioning, the question here is the reasonableness of the police conduct when they arrive on the scene. A number of factors that the court is.
Have we ever applied the medical emergency to a vehicle type situation?
I'm not aware that we have.
I mean, all the cases look like they deal with a home, which is a little bit more than, I mean, that would be, and you wouldn't want to stretch this too far, even if we did agree with you. You wouldn't want every time you had a vehicle abandoned, particularly an RV or a camper, you just say, well, somebody's in it, we can go there and take a look at it, because in North Carolina, there's RVs and campers all over the place.
Yes, Your Honor.
And people park them in a lot of different places, Sam's parking lots and all kinds of things. And it's, of the two exceptions here, which one would you view to be the stronger argument?
I think it is the community caretaking exception, principally because.
The impounding of the vehicle, which they don't seem to disagree with the decision to pound.
Yes,
is
Your Honor.
the inventory aspect of it.
Yes, Your Honor.
And that is because, why do you think that you should prevail on that?
Well, I think, given the underpinnings that we find in Caddy and then later in Opperman, the Supreme Court at least recognizes that the police are going to find themselves in not exactly this situation, but a myriad of circumstances in which we're going to interact with the public and automobiles. And in this particular circumstance, you did have the bank, the community requesting assistance. The police arrive on the scene, and again, the bank is saying, we need your assistance with this vehicle. I think principally, and that request kind of grows over time, or maybe even insistence, because as the police start to see in plain view these items, which the court has noticed, AR-15, weapons, ammunition, tannerite in plain view in the vehicle, they're asking the police to please assist them in towing this vehicle off. And that, I think that squarely falls within the heart of the
When you
community
say
care.
plain view, you mean someone just walking by it can just glance over and see it? Or you have to walk up to the window,
I
put
think
your
it,
hands up there and take a look in it? What's the plain view? How plain is the view, I should say?
but that's a good question. I know they did walk up to the vehicle to examine it, and they saw the AR. They also could see other things like a receipt, hotel receipt that was blocked by some other papers. So they certainly took a look in the vehicle pretty
The
closely.
AR-15 was leaning against the front seat, wasn't it?
It was, Your Honor, and there's a photograph of it. They noted, I think, in the record that where it was parked was near a sidewalk and then near a other area where people walk.
Counsel, do you have the option of, do we have the option of applying just one or the other? Isn't the medical emergency, doctrine or finding required to get enough information to do the inventory search, or is it your position that we could go down either route?
I think you could go down on either route, and certainly that the district court judge found on both bases.
You come to the same result, your position is, you get the same place, whatever you call it, whatever label you put on it.
But didn't the district court, maybe you know the record better than me, it looked to me like he almost went in a two-step analysis. That one, that the circumstances that allowed the officers to reasonably open the back of the van, and then at that point there were circumstances that justified the inventory search. Now, I think it's fair. Maybe that what they saw before they opened the van was enough to do an impoundment and inventory search, and that may be an alternative way. But didn't he kind of go at it in a two-step process, or you think I'm reading that wrong?
I think, to be fair, as we read the record, he talked about both processes, but said he found it reasonable based on both theories.
Okay.
Now, the court certainly extrapolated more on the community caretaking in its order than it did on the urgent necessity, but certainly the court spoke more about the community caretaking. Again, these circumstances also, and I think, Judge Wynn, you asked this question, don't we have to worry about how far we go? This case was notable, as the district court found, and as Captain Smith from the Kannapolis PD testified to, he had never seen anything like this in 20 years' experience. So this was a very unique circumstance, was not basically, our recreational vehicles in the Walmart parking lot. This was a circumstance in which they arrive on the scene. They see all these things, these indications, the California tag, a suitcase in the front, and I think Officer Lambert testified that he had had experience that people who were traveling or living out of their cars would have a suitcase with them. And they see this scene, and they're if the court does credit the findings of the district court, the door was ajar. And they noticed it, and that's certainly a very reasonable conclusion. I have this vehicle. I have what are obviously valuable things in the front. I have what is a suitcase, which would indicate you're going to be maybe living with or traveling in this vehicle. And then I see a door ajar. That is a completely reasonable conclusion that somebody is possibly inside the van. Now, notably, the police don't try and, in the record below, and I think that ultimately leads the district court to conclude that they're credible, is they don't try and say, we knew for sure that there was going to be someone in the van. They don't. They just, as they're on the scene, as they start to develop the circumstance, as they start to think about it, they even are calling a supervisor, and a supervisor, after hearing those same facts, said, you better check to make sure there's nobody back there, and that's what they did. We don't have, in terms of this reasonable analysis, we don't have a headlong rush by the police when they get there. Ultimately, the call from the record is about 2 vehicles. They're performing a community caretaking exception. The bank says, can you help us? We're trying to determine whose the vehicles are. Maybe it's a customer. Obviously, they don't want to tow a customer's car. And as they start this process, it's a slow, and the judge below thought about it. It's a slow, meticulous process as they go through this circumstance. Further, the police also are, in fact, confined reasonably by their policies because, as the record indicates, they are carefully considering, can we do this? And having conversations with the bank, and ultimately, after a supervisor with more experience consults with someone, they determine that, yes, our policy would allow you to do that, as it relates to towing the vehicle.
What's your thought on the fact that the policies, say, refer to the zoning administrator if you're going to tow a vehicle off private property? I mean, I know the testimony is that the zoning administrator would have, from their experience, involved the police necessarily in a situation where there are guns like this. But, is that is it a violation of the policy or that we should overlook because of overall reasonableness, or do you say that it actually complied with the policy?
We think it certainly complied with the policy.
Can you explain why that is?
If you look at the kind of the preamble to the Kannapolis ordinance in which the policy is based on, and I think it pleased the court that was government's exhibit number 14. There's a provision when it starts talking about it. It says that as they're explaining this kind of division of labor, who's got the junk cars, who's got the abandoned cars, et cetera, it talks about nothing in the ordinance is designed to limit the police in exercising their power. And so it is certainly, we think, police came to a reasonable conclusion. And even within
the decision, the ultimate decision was made by the police chief, wasn't it?
No, the ultimate decision was made by Captain Smith in consultation with someone
Captain
he
Smith,
named.
he wasn't the police chief.
He was not.
What was he? That's what I'm talking about. That's the one I...
Yes, sir. Captain Smith was head over, I think, an administrative division, which included, he listed it.
They had a captain on the scene.
Yes, Your Honor. And he consulted with a higher person within the police chain before he reached that conclusion. And so ultimately, the court found that the policy was reasonable, that they, in good faith, followed their policy, and the government says unequivocally that we believe that the policy allowed them to make this decision. And then furthermore, as the court has said, the standard here is reasonableness, even if the court says, well, there's a technical violation, that one step extra wasn't followed. We don't believe this court should find that to be per se unreasonable.
What about that inventory issue? I always thought if the policemen take custody of something, they're obliged to inventory it. They get burned, I know, at trial when they don't. I mean, I had some experiences when I was a prosecutor of the inventories being insufficient. And they, we complain about it and have to have hearings about it and all that kind of stuff, because they claim there was stuff there that wasn't designated and everything. The inventories weren't good enough. I thought they were going to take custody of a car. They had the inventory of what was in it.
Your Honor, I think that...
And here, actually, when they got into the thing, they found $500,000 in cash.
They did.
So I thought the claim about what that was surprised by.
You're right, and I think that is, the police indicated, and it's interesting, you kind of have three separate audiences here for this community caretaking function as kind of brought out at the hearing. One is the bank. The bank is asking for help. We've got a vehicle out here in a parking lot with a gun and a bunch of other stuff that's concerning. Can you help us determine who the owner is? Secondly, of course, although this ultimately ended up turning out poorly for Mr. Treisman, there's testimony in the record from the police on scene that one of the reasons we want to do this inventory is to protect whomever, who we cannot find who it is, owns these things. And they were valuable things. And certainly someone who had for whatever reason, left $500,000 nearly in a unlocked vehicle in a bank parking lot, that would be a good community caretaking function that we're helping.
Counsel, what's the, Mr. Treisman's counsel points out that, the officers not just called out the serial numbers, but ran the serial numbers. What's that have to do with either inventory search or, I guess that's what it is there, in securing the property? They say that's evidence that you're actually investigating a crime.
Well, certainly the district court heard that and didn't think, on balance, that tipped the scales to make it a subterfuge. But secondly, I think it was Captain Smith testified that once we take possession of a thing in an inventory, especially weapons, we run the serial numbers to determine are they stolen. So if someone shows back up at the police department and says, hey, you towed my car, I want the gun back, they want to check first.
So the testimony is that's part of the custom and procedures of an inventory search, that you would run serial numbers on weapons?
It was for the Kannapolis Police Department. And further, they also indicated, obviously, the police have a legitimate concern in making sure they're not returning a weapon to a prohibited person. So trying to establish who the owner is, taking down the serial numbers. But the court heard, obviously, and that was elucidated and weighed specifically by the court in its consideration, and did not tip the balance. The court has no further questions.
Thank you very much, Mr. Green.
Thank you.
Good to have you with us. Mr. Blau?
Thank you, Your Honors. And as I've noted in the briefs, I don't think this court even needs to address the impound and inventory ultimately, because the first entry into the van and everything that flows from that has to deal with whether or not there's actually a reasonable belief that there's a medical emergency here. And we have to remember, we have 2 officers on the scene for 90 minutes who testified that they didn't think at all that there was, or they had no reason to think that there was someone in the van or that there was an emergency that required them to enter immediately to render aid. It wasn't until an hour and a half after being on the scene on a conversation with another officer who wasn't even there, where that other officer said, well, it's a hot day, someone's probably in the back of that van, that's an urgent necessity, and you need to go in there to look. And then even if that decision's made, they still don't knock or call out or do anything. They open the van, draw guns, start moving some boxes around before they do anything else.
When did your client eventually show up? How much longer after these police were there and conducted their search?
It's later that afternoon. I don't think we know exactly when the van gets towed away, but I believe Mr. Treisman showed up within an hour or two after that. It was later that afternoon.
It was about noon or something that got towed away, wasn't it?
I think that the first officer, I believe, arrived sometime around 10:50 to 11 o'clock. Then the first entry into the van, I think, was around 12:30 p.m. It was sometime after that it was removed because they did the inventory. It seemed to have taken at least an hour. Of course, the inventory was done before they impounded the van. And Mr. Treisman, it may have been around 3 o'clock that afternoon. I can't recall exactly, Your Honor. But it was within a fairly short period of time. And as I noted in the briefs, I think that if the police had followed their proper procedure and contacted the city zoning administrator to see what they wanted to do and whether they would approve not only impounding the van but also waiving the 7-day notice requirement, that probably by the time that would have happened, Mr. Treisman shows back up and none of this has happened. The fact that they bypassed another government office who was responsible for the decision making, and they just said, no, we're going to make it on their own and we're going to cut you out of this process entirely, shows that, or is it just one of the factors that would show that they had a motivation of looking for evidence of crime in what they were doing?
Is that your best argument, that the wrong person made the decision?
Well, that's just one factor that this court has instructed courts to consider to determine whether there's evidence of pretext. If the police have...
That's not really, is that right? I mean, I guess the question is, are they in lawful possession? But, I mean, the question about procedures is really under the inventory search.
Well, right.
And, I mean, I get the argument that that's relevant in terms of whether they had lawful possession.
Sure.
But the case law that talks about following procedures really is not in that aspect of it. It's in the inventory search part of it. I know there's some connection there, and maybe that's hair splitting.
If you look, I think Your Honor is right, but if you look, and I realize I'm taking us out of the context of federal court, but the North Carolina case, Pfeiffer from the North Carolina Supreme Court, deals with almost exactly the same situation where officers are supposed to get approval from a particular person before they do an impound, not an inventory, but an impound, and they don't do it.
It doesn't even, I mean, the policy is a little less than emphatic. It said should be referred to the zoning administrator. It doesn't say shall be. It doesn't say can only be approved by. As I recall, it said should be referred. And you know, that's less, if I'm reading that right or remember that right, that's less than absolute. And they know that the zoning administrator always says y'all got to be the ones when there's guns there.
Right, and what the ordinance does do, if I could just answer Your Honor's question.
I may have had it wrong.
What the ordinance does do is it directs that decision and the decision to waive the required 7 days notice is supposed to be made by the authorizing official, which is the city zoning administrator under the code and the police orders. Thank you very much, Your Honors. If you have no more questions.
Thank you, Mr. Blau. We appreciate your work.
Thank you, Your Honor.
And we'll come down and greet counsel, and then we'll return to the bench and call this next case. Next case, may take their seats, please, or come forward. We'll call the case of, in number 22-1463 of Christian Santos Garcia versus Attorney General Garland. Ms. Wagner, you may proceed when you're ready.
Thank you, Your Honor. May it please the court, Jessica Wagner for the petitioner Christian Santos Garcia. The immigration judge here heard hours of testimony from Christian and his relatives, reviewed documentary and photographic evidence, an expert report, and hundreds of pages of country conditions submissions. After considering this evidence, the IJ granted Christian relief on 3 separate occasions. Yet each time, the BIA inexplicably reversed. Christian has 3 bases for relief, any of which is sufficient to grant the petition. The BIA's rejection of each of his claims was infected by legal error, either from failing to apply this court's precedent or by ignoring conclusive record evidence, or both. First, Christian is entitled to statutory withholding of removal on account of persecution for his membership in a particular social group, or PSG, composed of young male relatives of his cousin Emily.
So on that, counsel, what, on the particularity analysis, given that that your client identified that as a group, how do we know what the barriers, what the contours, what the limitations are of young males who are family members of his cousin Emily? Focusing on young, how do we know who's young, who's not young? Tell me how we know the boundaries of that group, given that part of it.
So, Your Honor, I think it's important to remember that under this court's precedent, and that's the Temu case,
Well, I know the argument that we can't look at just young.
Correct.
We have plenty of cases where we do look at the component parts, and you may be right, maybe we shouldn't be doing that. But assume for the second, we're supposed to actually consider the terms of the group that are involved here. If I have to consider young and whether it's particular or not, how do I know what the boundaries are?
So young, I think, again, it's very important to look at it in the context of the whole group, which is what
Okay.
the court says we should do in Temu.
Okay.
And in this case, the group exists because in Salvadoran society, young women are at risk from gang violence if they do not have a male, family member to protect them. And so in Salvadoran society, it's understood there's record evidence that talks about, this risk to young women from gangs in particular, that male family members are supposed to protect them.
Okay,
and it's not an older family member. So in this case, Christian is living with his grandparents, his 3 sisters, and 3 female cousins. His grandfather is very old. His grandfather is not the one who's going to be going out and protecting, his sisters and his cousin from gangs. It's on Christian, who is the young male of the family, to do that.
But I understand that, and factually, I get that. But we're supposed to look at the group and decide whether it meets the particularity requirement. And given that young is part of the group, how do I know what young is? I mean, is it age such and such and below? I mean, how do I know if someone's younger? I mean, we got a panel here, probably none of us are young, but some of us are younger than others. What's it mean?
So I would certainly agree with the court that, at the borders, perhaps young is amorphous. But I think in this case, and the majority of cases, it's very clear. So when this happens, Christian is in high school. When he applies for relief, I think he's about 20. Christian is now 25. He clearly falls within the boundaries of a young male.
But is that our question, whether Christian falls within it, or is our question whether the group as advanced by your client has any contours so that we can tell who's in it and who's not? You may be right. I mean, Christian may fall in it quite naturally. But if some people might say young is minors. And if that's the case, he's not. And isn't that our problem? We don't, with that group, we don't know really what the boundaries are. And if we don't know the boundaries, maybe he would have been in it almost under anyone. But how do we know what they are?
So the question before the court is whether or not you can look at a group and decide if there's a benchmark, I think is the language court has used.
What was the particular social group definition that was used in the Crispin Valderas case?
In Crispin Valderas, the social group was relatives of those who testified against gang members, publicly testified. And, Your Honor,
That would be broader than this, wouldn't it?
I would think that the Crispin Valderas PSG is far broader. So relatives, here, I know the government has argued that young male relatives of Christian's cousin Emily, relatives can be expansive. In Crispin Valderas, relatives.
Where did this young come from? Because if you look back at the PSGs before the immigration judge, it didn't have that modifier young in it. The immigration judge put it in the order. So what do we make of that? I mean, it doesn't look like the council came up with this group. It looks like that's kind of what was put in the order.
Yes, so Your Honor, my understanding there were various iterations that were proposed before the immigration judge. And obviously this is the one that she landed on, and that's the one that the BIA considered and is before this court because there were other iterations raised. If the court thinks that we should look at something, say without
I'm
young,
not
like
going
male
upon
relatives
what
of.
the particular group was that was, but when I look at the proposed, particular social groups that were put before, none of those proposals had the word young in it. It came somewhere from the immigration judge.
Yes, I'm not sure exactly the contours of how she brought that in, but again, I think
Take a look at that differentiation. It seems like the council didn't bring this term into it initially.
Yes, I mean, again, my understanding is that there were various groups that were proposed, and if this court, and I think we had a footnote about this in our brief, I think it was in our reply brief, if the court, doesn't like this group, it could remand to consider one of the alternative formulations, for example, male relatives of Christian's cousin Emily without the young. I think, again, the young is important because, or I think that I'm assuming the reason why the immigration judge put it in is because it was from Christian's testimony about Salvadoran society and it being incumbent on younger male family members to protect their female relatives from
It was a
gang
limiting
violence.
term to the thing, right? I mean, it's a limiting term to the group. As we mentioned before, the Crespin case, and I've shorthanded it here,
Exactly.
was broader than this.
Exactly, Your Honor. We think so. It's very clear in this court's precedent that a family-based PSG is cognizable. And here we have not just a family-based PSG. We have additional limiting terms. We have young, we have male.
But you could limiting it, I mean, I think Judge King's right. It does limit it, and it's less broad than family members. But the issue is, family members, we can figure out who's in and who's out. And once you put young in there, I don't know how you figure who's in and who's out. I might say Christian's in, okay, but that's not our test. Our test is whether when you have a category, can we figure out who's in and who's out?
Your Honor, I would respectfully submit that in the majority of cases, it would be very easy to figure out who's in and who's out. So first of all, you have to have a male family member of Christian's cousin Emily. And then you're going to look at the family member and ask if they're young. And
What if they're 35?
I would submit that that's still young. I think that they're, just because at the extreme margins, maybe we're getting into the 40s, there might be some questions, doesn't change the fact that there are clear contours to the group. It's easy to apply. There's no question that it applies to Christian here.
What would be the problem with just simply saying male family members of his cousin Emily, which is what was proposed by the council? I mean, seems like you wouldn't be up here answering questions about young if you didn't have that modifier up there.
Yeah,
You seem to be arguing vigorously that it should be in there, when it looks like to me, at least whoever this council was at the beginning didn't have it there.
Well, Your Honor, I'm defending the IJ's decision. But I agree with you that male
I
relatives.
understand that, but IJ's decision has to comport with what you were asking for, even to the extent it did. And if it can be supported, not inconsistent with what was being asked for, it just had something additional in it that's not necessary. So
Right.
even in defending the decision, if he puts in a word young, he says, the IJ's decision is correct, but you don't need the word young in there. That's the argument that would be made. It wouldn't be, oh, we got to have young in there because Judge Quattlebaum's going to ask me about young over and over again, so I want to keep going back and forth on it. I don't follow that.
Yeah, I mean, I'm not submitting that young is in there. I'm saying that's what the IJ found, what the BI
He
reviewed.
did, but I'm only saying if everything he has in there can be supported with simply male, because that's what you asked for, you could. I could see you saying alternatively, yeah, but young is there, but it doesn't necessarily have to be there because we didn't even ask for it.
Yeah, and I
So
think
you could uphold this even by saying this is the particular group and it's supported by it.
And I think
I'm
that
not
was-
making your argument. I'm just simply saying it.
Well-
Listen to me. I don't know why
I think
you
he's
keep
making the
going-
argument pretty good.
I don't know why you keep going back and forth Judge Quattlebaum on this young thing here when you didn't even ask for it.
I'm certainly open to that, Your Honor. I mean, that was the footnote in our, I think again, it was in our reply brief about the alternative formulations.
Is
We're
there
open to
anything
that.
wrong with our precedent in that Crespin case? I mean, does the BIA and the Attorney General hostile to that or anything?
Hostile to what?
Hostile to the definition was used in the Crespin case. Crespin Valadares.
I don't
They
think,
just said family members. It's broader than what you have here.
exactly,
And we proved that. I was on the panel.
yes.
Judge Motz wrote the opinion. That was 2011. And as Judge Wynn points out, this added young male, who however got in there, to family members. But in Crispin, as I recall, it was family members.
Yes. And that's exactly why we think that it's so clear
If
that this,
Crispin is good law,
right,
this would have to be good.
exactly. That's exactly what we think. It's so clear that
Well,
a family-based
why is that?
PSG is sufficient.
Why is that? That's an interesting concept. I mean, I'm not quarreling with Crespin. I think, family members of a group is an identifiable group. Anyway, I've made, let me ask you a separate question, because we may just have, Judge Wynn talks about, maybe it would have been more appropriate, maybe you want to argue alternatively that male family members. But when you were answering my questions earlier, you were saying that young family members actually matters for the social distinction part, that it's young family members who are the ones who are expected to protect females from gang members. And so it sounded like that actually mattered to you on the other prong of our analysis.
I wouldn't say that being young mattered because it's very clear.
Didn't you say that before? You said the grandfather wouldn't be the one who would expected to do it. It's got to be the young ones.
Well, I was trying to explain the factual context for how the PSG came out and how the immigration judge put young in there. But, because it's very clear in Crespin that family members by themselves are socially recognizable. It's so that's there's no question. So, young here, again, adds some more context to the Salvadoran society. It makes the group narrower, but I don't think it affects the analysis in any way. And again, I would point this court, in Temu v. Holder, the PSG there was individuals who had been diagnosed with bipolar disorder and were erratic. And this court said that on their own terms, it couldn't imagine that either of those were particular, and especially said that with being erratic, exhibiting erratic behavior, how do you decide what that is, that wouldn't qualify. But it said altogether there was no question that it did qualify, and that's exactly what we have here.
Yeah, I think that's your best case, and what we got to grapple with is that case in relation to Lizama and Zelaya, which really did focus more on some of the component parts. They looked at it as a group, but they said some of the component parts made it too amorphous. And I think those cases figuring out how they align is an interesting question. So I think Temu is if I'm saying that right, is the right, is probably your best case.
And the other thing I would point to the court to is the BIA's own decision in matter of Kasinga. This is cited in our briefing.
Yeah, but you also have the subsequent matter of SEG, which I think, is hard, which I think is a precedential decision. I can't remember if Kasinga was. Do you remember that?
My understanding is that Kasinga is presidential, and that's the one where the BIA approved of a PSG of young woman of a tribe who had not had female genital mutilation.
Right.
And so there it's young women. And so if the BIA itself is approving of PSGs with young women, I think that there's no question this court can approve of a PSG that's young male.
But SEG, which is subsequent, and I thought was precedential, I can check and may be wrong, talks about, it actually says that, I can't remember the full group, but it had young in it, and it found that it was not particular. And so, anyway, I don't think the BIA is on, hey, young doesn't matter. I think that case has got to be considered too, right?
Yeah, but again, what matters most is this court's precedent, and it's clear under Crespin that family-based PSGs are cognizable if you add in additional terms.
That's not your, what's the authority that says if you have a group that's recognizable and you add additional terms, it's automatically particular?
So I think that, again, the whole analysis of a PSG is, is this group limited? That's a particular analysis. So I think it just logically follows that if you have a group that is already particular and you add even more limiting terms, that it's necessarily particular.
Is there a case that says that? If you have a group that is particular and broad and you add terms that might mean fewer people are in it, but it's harder to tell the boundaries, is there something that says we have to find that as particular?
Well, even in Crespin, it was family members, but then it was family members of people who had testified publicly against gangs. So there was clear, and in other cases, the court has approved of PSGs that are just family members. So in Crespin, you have additional limiting language.
I don't mean to go on and on about this, I probably am, but I'm just trying to ask you a question, and if there is one, that's great. If there's not one, that doesn't end things. But is there a case that says if you have a broad group that is particular, and then you have add modifiers that may mean there are fewer people in it, but it makes the boundaries harder to figure out. Is there a case that says we have to find that's particular?
I'm not aware of a case that puts it in exactly those words, but there are multiple cases where you have something like a family-based PhD that has additional modifying terms added, and I would argue that's exactly what we have here.
Okay, thank you.
Let me ask you this. The bottom line, what do you want us to do with this case?
So we would request that you hold that the BIA legally erred by failing to apply this court's precedent, most obviously Crespin-Baladeras, that family-based PSGs are legally cognizable, and that as a result, Christian is entitled to withholding of removal. We would ask that you not only grant the petition, but also that you reverse the BIA's decision and hold that he is eligible for statutory withholding of removal.
So you want withholding of removable and cat relief?
Correct.
And what would that do for him? As I understand it, he is now in El Salvador.
Yes. So under, there's an ICE directive.
And it would go back to the BIA if we did that, right?
I think that if you found that he was eligible for statutory withholding.
No. Just answer my question. What would that do for him?
So
If we were to grant the two types of relief that you just said, withholding of removal and cat relief, it would go back to the BIA. What happens to him? He's still in El Salvador.
So if you hold that he
Doesn't bring him back to the United States.
if you hold that he is eligible for withholding of removal and cat relief, it goes back to the BIA to, I think, officially grant that. But then under an ICE directive, we are able to petition for him to be brought back. And someone who is granted relief so that they're eligible to be in the United States, ICE is required to then bring him back if we go through this petition process for that. And it would be helpful.
You mean we can require the government to bring him back?
Correct.
I didn't know that.
Yes. And we can, so there's an ICE.
But you'd have to bring a separate petition to do that?
So yes, there was a process to petition through ICE.
So it wouldn't happen in this proceeding?
So two things. So first of all, this court can enter, in its opinion, it could direct that ICE bring him back, which automatically will speed things up with ICE. And if the court doesn't do that, we can go to ICE and ask that they do it. It's obviously much easier.
So
We
you
prefer.
got cases where the court can order that and they do it?
Yes, there are multiple cases where the court has ordered that. So I would direct the court to, and this Ramirez v. Sessions.
If they're in your papers, we'll find them. I just wasn't aware of it right now.
Yes, we didn't actually address this in our papers, but there are multiple cases, and I'm happy to submit a supplemental letter if that would be helpful.
That'd be helpful to me.
Okay.
But there was something else I wanted to ask you, but I can't remember what it was.
Okay, well, you can ask them when I come back for the bottle.
If you have to go through those proceedings, are you folks going to stick with him? I mean, he's got one of the best law firms in the world, and you've done a terrific job. But how long are you going to stick with this guy?
So we have been with him for a long time. We have been with him through the IJ, the BIA, and up. I mean, I can't imagine us leaving him hanging now. We will continue to represent him.
I'm curious. I appreciate what you've done.
No, we did not just join this case at the Fourth Circuit, to be very clear.
Thank you.
Thank you, Your Honor.
Ms. Rourke, good to have you with us, Ms. Rourke. And you represent the Attorney General of the United States.
I do. Thank you, Your Honor. May it please the court. The INA is clear. Not every person who is harmed in their country of origin or who fears harm upon their return will qualify for one of the narrow forms of relief and protection from removal. Before the agency, petitioner bore the burden of establishing a clear probability, not just that he would be persecuted, but that a protected ground would be at least one central reason motivating his persecutors to harm him, and a clear probability, not just that he would be tortured, but that the Salvadorian government would acquiesce to that torture. And now before this court, petitioner must show that the record is so compelling that no reasonable fact finder could deny him withholding of removal or cat protection, which we submit he cannot do. The first issue I would like to address is whether the extended family groupings at issue in this case satisfy the requirements of a particular social group. And at the outset, I think it's important to note the exact particular social group articulated by petitioner, which is young male family members of his cousin Emily. Not Emily's nuclear family and not Emily's cousins.
Would it satisfy it if it didn't have the word young?
So Your Honor, we would still think that petitioner's group did not satisfy the requirements of particularity and social distinction, even if the group did not have the modifier of young. A claim based on family membership will often turn on the nature and degree of the relationships involved and how the society in question views those relationships. And that is why the board determined that his group does not quite fit the requirements of particularity and social distinction. Petitioner's main contention here is that this court's precedent.
Been the cases, as you look at them, and granted, it seems that each one sort of turns on different types of facts, but we've been pretty open when it comes to family-based ones, and to simply say male members, why is that? Does not fit in line with a number of cases where, as Judge King pointed out, there may be even broader classes. And I granted, Judge King seems to be looking at this a little different than Judge Qualibon in terms of what that means to put young in. That looks like it's a subset, where, on the other hand, it could be viewed as it's not a subset. What it is, it takes you out to examine an unknown. You don't know what the young is or what it is. So there's two different views on it. But if young is the problem here, if you took it off, does it satisfy this particular social group?
Right. So we would argue that, or at least note that a question of whether a particular social group exists in the society in question is an individualized fact-based inquiry, which is done on a case-by-case basis.
But particularity is a question of law. We held that in Amaya. And so particularity, I think Judge Wynn just logically is right. I think, you know who males are, you know who family members are. It may be broader, but you can figure that out, right? So under Amaya, I think that's probably, particular. The question then is it socially distinct? And does society is there evidence that society in El Salvador views that group as an actual group, not a bunch of words that are put together, but a real group? And I mean, I would think if you hypothetically, I say it's hypothetically, maybe it's not hypothetically, change this group from young males to males, probably is immutable, probably is particular. The question then, is there evidence that in society, not this neighborhood, it's viewed as a distinct group?
Right. So we would argue even if the modifier of young goes away, in terms of social distinction, petitioner's case would still not satisfy the requirements of a particular social group. And I think it is telling in petitioner's opening brief, this is at page 38, they cite to a single source as evidence of social distinction. This is the UN Refugee Agency guidance note located at page 1576 of the joint appendix, which discusses asylum claims for Central American asylum seekers, and it states that a family member of a gang or a sister could also be persecuted for reasons of his family membership. This evidence is insufficient to compel the conclusion, contrary to the agency, that petitioner's group is socially distinct, first because it is the perspective of society as a whole that matters, not just that of the alleged persecutor, and because this article is not specific to Salvadoran society as a whole. It discusses gang violence in Central American countries, not just El Salvador. So we would think even if this court was inclined to find the group was particular, it would still fail on social distinction grounds. There's no evidence that addresses how Salvadoran society perceives family or how extended family groupings are recognized in Salvadoran society.
Is there evidence about, and y'all know the record better than me, and I didn't ask this to your colleague, I'll do that on rebuttal time, but is there evidence in the record, we talked a lot about particularity, but on social distinction, is there anything in the record about how society in El Salvador views young male family members, that group, young male family members?
No, and that's the problem here is petitioner's evidence doesn't address what type of familial relationships are recognized by Salvadoran society in general as so significant that society distinguishes groups of people based on those type of relationships. So even if petitioner's group was limited to nuclear families or cousins, he still couldn't win because there's no evidence about.
Well, the trouble with that, though, is we have cases that say nuclear family and family members are, legitimate
particular social group. So maybe there's no evidence of that, but you got to deal with our precedent. Here we got something that I don't think is controlled by our precedent. So I think it's fair to see what the record says.
Correct. It would still be an individualized case-by-case analysis in terms of the social distinction. The board has repeatedly held to establish a claim based on membership in a PSG. The applicant will be required to present evidence that the proposed group exists in the society in question.
We've been pretty strong on this family group. You look at the Crespin case. Uncle and nephew is a cognizable group. We held that, right?
Correct, but
So when you look at that, we're not just talking about nuclear families. Does it matter as to whether they're uncle and nephew related by blood or by marriage?
So the group in Crespin was actually family members of those who actively oppose gangs by agreeing to be prosecution witnesses. So it was not a group between the uncle.
Which seems to me to be much broader than what you have here. Do you all accept our decisions as precedent?
Yes.
You do?
Yes.
We do think. I've had some of your colleagues come down here and they were very critical, wanted the panel to change the precedent.
Right. So we're not arguing that.
So you accept Crespin?
Right. We're arguing that it is distinguishable. In terms of particularity, we feel that it did contain additional.
So what's the distinction between this case and Crespin then, in your view?
So in terms of particularity, we would argue that there was additional limiting language in Crespin, and while the issue in Crespin certainly centered on a class of family members, rather than persons who agreed to serve as witnesses, the court did not view those two classes in isolation from one another. As counsel was saying, the point is to view the group as a whole. The court observed that we conceive a few more groups more readily identifiable than the family, and this holds particularly true for Crespin's family, given that Crespin and his uncle publicly cooperated with the prosecution of their relative's murder. And then in terms of social
The
distinction.
distinction here seems to be, when you look back at what the factual findings that were made on this family, they talked about being known in the community, how they operated a grocery store, and they lived there. And the board actually acknowledged that the group was socially distinct in the local community. Then it went and said, but the distinction is not throughout the country. I don't understand that from our precedent, because I'm not sure that's a requirement as it being country as opposed to there. And as has been noted, the problem we've got cases all over the place. When you start talking about particularity, we're talking about definable boundaries for which you can make sufficiently clear as to who is in and who's out. And when you're looking at this case and determining it, you can turn the words on this thing and make it fit however you wanted to make it fit. You can say definable borders here refer to a single member of the family, Emily, who, and it excludes anyone who is not young. I mean, it actually makes it more particular, as could be argued, because you're talking about a particular part of the family, young male members of that family. So it's odd, and this is where getting to be a judge gets to be artful, I guess. It's just the way you say it is where I'm putting it. And so ultimately when we get here, we're going back and forth on this whole business of is this a particular family or not? But there are cases all over the place that would defy common sense as to why they don't all follow precedent of being in there. So why don't we why not just make it simple and says, okay, family-based members make it. Then we get into the whole particularity context of it, and there's an argument as to whether, well, seems like to me it's pretty particular to say, it seems more particular to me to say young male than to say males.
Right, so the question.
Well, it is more particular.
Right, so the question isn't.
It is more particular because it excludes the females, right?
Correct.
Is it more
females are-
particular?
So it's more particular.
Is it more particular or is it more narrow?
Right, so again, we think.
Both.
We think the boundaries of petitioner's group are
And you're saying you don't know what young means.
Correct.
You're saying you don't know what young means. The Attorney General of the United States over the years has used what Congress called the Youth Correction Act. I guess they still use it. When I was a prosecutor, we always had people talk, we had the issues, but applying the Youth Correction Act to young, mostly male, but wasn't male, but young criminal defendants. And everybody knew that was 26 and under. The Attorney General enforced that. The Department of Justice. They applied that to people who came into the federal court system.
Correct.
That's who you're representing today.
Correct. For the term youth, the board has long held that youth on its own does not have any strict objective boundaries. And going back to Judge Wynn's question, I'm thinking this is what he was getting at. So the question isn't whether petitioner's specific family is recognized by society. It's whether the type of family relationships that are used to define his group are recognized by society. And I think that's important. So even if, yes, petitioner's family was well known in the community because they ran the store, they lived above the store, that's all well and good, but it does not address what type of relationships are recognized by Salvadoran society as so significant that they distinguish groups of people based on those type
So you
of
buy in
relationships.
with the distinction that it should be a country-type distinction. You can't, the family unit can't be defined by a local.
Not necessarily, Your
And
Honor.
I mean, when you think about different countries, you know that within the country itself, there can be different definitions. You might say that's true in the United States, in certain places, but I won't say that. I won't go there.
And with that argument, aren't you changing Crespin?
With the social distinction, I don't think anything in Crespin said that, unequivocally that all
You're
family.
stretching it, you're alternate. You want us to change it.
We don't think the court needs to touch Crespin. Again, we said it was distinguishable, and I did discuss how it was distinguishable in terms of particularity, but also in terms of social distinction. The record in Crespin contained evidence of social distinction, including expert witness testimony that gangs murdered government witnesses and also intimidated witnesses by attacking their family members. There was also evidence that Salvadorian legislature had enacted special protective measures for those testifying against gangs, which suggested that society saw this group as specifically very vulnerable. Whereas here, again, there is that lack of evidence of social distinction. So I do think it is distinguishable from this court's decision in Crespin, and we're not asking you to alter that.
So, counsel, let me switch
I
gears.
interrupted Judge
I'm sorry.
Wynn, I'm sorry.
And,
No, I'm fine.
You want to finish something?
No,
Okay.
I apologize.
We've been talking a lot about the withholding claim, but there's a CAT claim too.
Correct.
And in the CAT claim, the IJ talks about a number of pieces of evidence. And you, in the BIA, I guess vacating or reversing the CAT claim, talks about only two of those pieces of evidence. And your opposing counsel says, hey, they didn't, that you can't do that. You can't just selectively pick two and not consider all the evidence. What's your response to that?
Right. So as we pointed out in our brief, the board is entitled to the presumption that it considered all relevant record evidence. And I think what the board was trying to do here was focus on the primary evidence that the immigration relied upon. These
But
were.
it didn't say, it would be easier for you to argue that if it said, for example, two of the pieces of evidence they found are these two articles.
Right. But the immigration judge in her.
And how do you not address credible testimony of Garcia, which is right there? He said he faced this prosecution by governmental actors. And you say you're looking at the big evidence. That's big in terms of whether he feared for prosecution. That didn't even address it. How is that not something we would have to send back for them to consider?
Right. So in petitioner's CAT claim, the immigration judge found that he was only eligible for CAT protection by aggregating the risk of torture from three different sources, which were the gangs, the gang extermination groups, and the Salvadorian police, and that it was not more likely than not that he would be tortured by one of these sources alone. For this reason, the board noted, this is in footnote number 4 of the March 30th decision, that because police were the only public official from whom petitioner feared torture, the immigration judge had implicitly found that petitioner did not face a greater than 50% chance risk of torture by a public official, which would not require a showing of acquiescence. The board then turned to the remaining evidence, as Judge Quattlebaum was discussing, relied upon the immigration judge, which included two pieces of evidence, which the immigration judge devoted 2 full paragraphs to discussing. And this was the main evidence that they had relied on as evidence of acquiescence. This was
Why do you say that's the main evidence that they relied on acquiescence?
It was the evidence that the immigration judge discussed in depth, and it was the evidence that the immigration judge said that these are examples of when public officials turned a blind eye or acquiesced to torture. These were the two pieces of evidence she relied on to show that the likely response from a public official would satisfy the regulatory standard for acquiescence. So she did generally also discuss evidence about police abuses and extrajudicial killings, but that would be torture by a public official, by the government itself. This is just the evidence that pertains to acquiescing to petitioner's torture, either by the gangs or the gang extermination groups. And the board here found that that did not satisfy the standard for acquiescence. If there are no further questions from the bench, I would respectfully ask that the court deny the petition for review and uphold the agency's denial of withholding of removal and cat protection, as well as its denial of petitioner's motion to reconsider.
Thank you very much.
Thank you.
Ms. Rourke, it's good to have you with us. Ms. Wagner?
Your Honor, I'd like to begin by addressing the cat claim. So, counsel for the government just said that the immigration judge found that any one of these three risks on itself was not sufficient. Or she didn't actually say that. I'm going to read her language. This is JA 1271. She says, the immigration court finds that the likelihood of torture may not be more than 50% for each individual threat. But here there were three threats. And so even assuming, and we strongly contest that, we think that the BIA erred by finding that there was no acquiescence. But even assuming for a second that the BIA was right and that somehow the gangs were not one of the components for CAT, the BIA was then required under Rodriguez-Arias to go ahead and aggregate the risk of torture from the remaining two sources. And simply saying that any one of the three sources may not have been, 50% or more doesn't get you, each of them could have been 30%. So if you have two sources, that leads you to a 60% risk. If you have
So does that mean, I think I understand where you're going about the aggregation, but is it your position that if there's evidence of more that the petitioner is more likely to be tortured upon return, and that comes from three sources, each of which is under 50%, and only one of them is done with the acquiescence of a government, that you win?
Yes, so
I mean, doesn't all your evidence that supports, that adds up to more than 50%, have to be done with the acquiescence of government?
no. So again, there was three sources that the IJ relied on in this case. So it's the 18th Street Gang, Salvadoran police, and the anti-gang vigilante death squads, who are composed of police members. And so for the police themselves and the anti-gang vigilante death squads, acquiescence is not required because those are government officials who are acting.
I got
exactly.
You. Yeah.
And so even if you knock out, and we strongly disagree, and I'm happy to walk through the court, how the BIA legally erred in dismissing the evidence of acquiescence. But even if you somehow agreed with the BIA that acquiescence, that you take out the gang, those two other sources needed to be aggregated. And that is a clear legal error under Rodriguez-Arias, which says you have to evaluate the risk from all of the sources. The BIA never did that. The government doesn't address that in their brief, so I would argue they've conceded that error. And so that, at a minimum, is a reason to grant the CAT claim. But we think that it's very clear when you look at the record as a whole
I'm sorry, counsel. You finish your point. I didn't mean to. I interrupt you. I want you to finish your point. I'm sorry.
Oh, I was just going to say, when you look at the record as a whole, we think it's very clear that Christian is entitled to CAT relief, as the IJ found. And, the BIA ignored, as Your Honor is reporting out, clear evidence of acquiescence. So in the BIA's decision, they say there's only two pieces of evidence. When you look at the IJ's decision, she discusses 6 pieces of evidence, 5 of which supported Christian.
That's not really fair. I think it's fair that, I don't mean to be as critical as that may sound, but I think the BIA only talked about 2 pieces of evidence. The BIA didn't say there were only 2 pieces of evidence. I think it's a good point. You have a good argument that the way they did it, they didn't say, for example, and it could have been different. But then at the conclusion,
you know, they're talking in a more collective way. Yeah, I mean,
So, Your Honor, this is the quote from the record. This is JA 969. They say, as proof of acquiescence, the immigration judge relied on two pieces of evidence.
Okay.
A 2019 Washington Post article and then a 2019 article from a think tank. So they don't say even what Your Honor is saying. They say two pieces of evidence. The BA clearly or the IJ clearly discusses more, which, you know, we would argue
agree with that.
illustrates that she looked at the entire record.
Yeah.
And then beyond, and that's all country conditions evidence that we're talking about, there's also the evidence from Christian himself, the testimony about acquiescence. He testifies that the police in his neighborhood regularly take people and dump them in rival gangs' territories, and that's confirmed by the country conditions evidence.
Can you answer the question I alluded to a second ago about social distinction? Do you have, if you could just, and I'm not, maybe JA sites or whatever is the best way to do it, but assuming we're sticking with young male family members of Emily, is there anything in the record that talks about how society as a whole now views the group of young male family members?
So there are two pieces of evidence that I would point the court to.
Okay.
The first is Christian's testimony before the IJ. That's at JA 1292 to 1403. And that's where he talks about, you know, Salvadoran society. That's what the IJ primarily relies on when making this finding. But then I would also direct the court to JA 916. And that's I believe, an expert report. And there, that,
What report?
I think it's either, I want to say it's an expert report.
Okay. Okay.
But it is, in that report, discusses how women in Salvador, how it's a patriarchal machismo culture in El Salvador, and young women who, you know, are single and don't have family members face these heightened risks, which is exactly what I was talking about earlier, is that because of that, you know, because they're so vulnerable, the men and their family are expected to stand up.
Thank you very much.
If there are no further questions, we would ask the court to grant the petition for review and reverse the BA's erroneous decisions.
Thank you very, very much, Ms. Wagner. And we will come to the well of the court and greet counsel, and then we will take a short break. Be seated. Our third case of the day is Darrell Howard against the City of Durham. Two consolidated appeals, number 22-1684 and 22-1719. Ms. Hoffman? Good to have you with us, Ms. Hoffman.
Thank you. May it please the court, I represent plaintiff Darrell Howard. The district court erred in deciding factual questions adverse to the plaintiff and thus improperly dismissed claims against Penica, Susie, and the City of Durham. In 2011, there was an extraordinary development in this case. DNA implicated a new suspect, Jermac Jones, in the murders for which the Durham Police Department had helped put Darrell Howard in prison. Scott Penica, the sergeant in charge of homicide, reads up about the case, he meets with his supervisors, and he expresses his concerns about potential liability for the Durham Police Department. He then participates in an interview of the suspect, Jermac Jones, which was rare for him as a supervisor. He tries to feed Jones an innocent explanation for the presence of his DNA inside the dead victim, and it fails.
Give us the posture of the case we have here. When I saw you stand up first and I recognized you got a $6 million verdict, I was wondering what's going on here, but then I recall this is a cross appeal. So various issues are coming from both sides. So I know the way in which you postured the cases, it looks like the council divided themselves up. A lot of times when we do that, what happens is it gets lost in the process, who's arguing against what. So outline to us what we're about to hear today and what you anticipate is going to come, if you can. You don't have to do that side, just yours.
So there's three issues that we're raising here. Two are about the dismissal of other parties at summary judgment, Penica and Susie, who are individual investigators, and then the City of Durham itself. And the third issue is about error at the trial that infected the damages award. The reason that all of this is significant is because, as noted in the papers, Durham is contesting its obligation to indemnify the individual officer. And so it's unclear whether they will pay the verdict against Dowdy. There's litigation ongoing about that, which is separate from this. And so holding additional people responsible is necessary to collect. And there's also a question about the size of the error in the express propensity argument made at the trial and character that infected the damages verdict.
So you're appealing the verdict of $6 million.
We're appealing the dismissal of two additional parties or sets of parties.
I heard that part, but I'm starting at the bottom now.
Yes.
You're actually appealing the jury verdict.
We are asking for a new damages-only trial.
So you're giving up that amount of money, you want to start all over and want more.
Well, yes, because we believe.
But you don't want to give up your liability determination.
Because the error in this case, there's no error that infected the liability determination. So the jury found within a few hours.
Why is that necessarily true? I mean, some of the maybe I'm wrong here, but some of the evidence that you challenge in relation to infecting the damages was explaining what the officers did and knew that justified what their charge against your client initially, and that were used in the prosecution of him. So it seems, it seems a little difficult to me to just automatically say all this evidence related only to damages and not to liability at all. That seems like an awful fine line with how trials actually work.
Well, first, if there was error, the error was against the plaintiff. So if the plaintiff then won, there's no indication that would have, it didn't have an effect. It was harmless to the extent it would have had an impact on liability. But also here, the issue is not solely the introduction of evidence, although we believe that there was extensive evidence introduced improperly. There's an express argument made during opening and closing, that this is a propensity an express propensity and an express character argument, which is completely contrary to the federal rules. And so this is exactly what this court said you cannot do in Kopp v. Skirm. It's much more blatant than what this court reversed for in Smith. In Smith v. Baltimore City Police Department, there was an implication based on a question that was asked about this isn't your first rodeo, one question about prior arrests, that the jury might have interpreted that as propensity or character evidence. They said the quiet part out loud here. There's no implication. They expressly said to both the court and to the jury that the damages should be lower because of who this man is and the choices he made. Expressly said to the court, the argument was he might have been wrongly convicted in this case, but he would have done something else. He would have been in prison anyway. That is a blatantly improper argument. It should not have been permitted. The court recognized it was improper and did nothing to address it. So
Was there any objection to the argument at the time?
There were objections throughout. There was objections.
Was there an objection to the arguments
Yes.
you made at the time it was made?
Yes, and we went to sidebar.
And they were overruled?
It was, no, the court stopped, but he didn't instruct the jury in any way that there was anything improper to
Did you
disregard
ask for
it.
an instruction in any way?
I believe we asked for it, yes, throughout. We'd asked for, and we flagged this.
Are we reviewing this? Is this a preserved point, or is this reviewed for something like plain error or something?
It's preserved. We flagged this issue in pretrial conferences. We flagged it
Well,
throughout
I'm
the
not talking
trial.
about it. That pretrial conferences, I don't think does it. I think if you claim a bad argument, I think you have to make an objection at the time the words are spoken to the jury that you complain of.
There was an objection made at the time. It was preserved. It went to sidebar. The court recognized at the time that the argument did not have a basis, and he told the counsel to move on, but did nothing ever to instruct the jury that to disregard it, to correct it. There was nothing done.
Did he instruct more broadly about the purpose for which some of this evidence was to be considered? Was there a limit? I realize not in the argument stage. I understand your point there. I can't remember if but you know the record way better than me. But it seems like I recall a limiting instruction on this evidence that was given.
Even the instruction that was given, for some of it, I don't think there was any limiting instruction. Like, I don't believe there was an instruction about the arrests. But for other things, for example, the number of times that the plaintiff had been shot before, which the stipulation was he was a victim in each one of those times. There's no evidence that this is indication of his own violence at all. And the parties all stipulated to that. The court instruction was you can consider this for damages, but it doesn't say what that meant. And the argument that the expressly improper.
But you had an expert who talked about his post-traumatic stress syndrome and related to the time in prison. And as I recall, the district court said, look, I mean, if that's an argument, you've kind of opened the door to different ways that might have affected that particular diagnosis or the symptoms that come from it. So, I mean, that's what I recall about this being shot.
That was the argument that the defense made at the time, which is why the court permitted, which ended up being extensive examination about the number of times that he'd been shot before. However, when you get to closing, they never made that argument. They never suggested that. They did not mention PTSD. Instead, what they expressly said is he's been shot this many times. Those are the choices he made. And explained to the judge at sidebar when they interrupted the closing and went to sidebar and we objected and said, they're making exactly the argument we told you they were going to make. He's a bad person. The jury should lower their damages award on that basis. The argument they expressed was he likely would have been in jail for something else. The jury can find that. It's an express argument about violence and propensity.
Why isn't that, I mean, look, I'm not saying it's the clearest. They said it in the way that is most clear, as I'm saying, but why isn't that explanation at least connected to damages? I mean, you're seeking, damages for being wrongfully imprisoned, and I get that. I mean, I don't know how you calculate something like that. I thought their argument was, not that the damages should be reduced because he's a bad person. I thought their argument was you have to compare what the horrible horrible situation he endured for being in prison wrongfully with what his life experience would have been had he not been in prison. Is that not a fair issue for a jury to consider in terms of what the damages were?
I mean, I think in the context here, it's very clear that what they were arguing, and literally the words they said, who this person is, the choices he has made, that is a character argument. Expressly saying to the judge he would have been in prison again, that is speculative. There's no evidence of that. The only evidence is improper propensity. And the issue is, it's not that there's no possible relevance to this. The reason that the federal rules prohibit this is because there's an understanding that people are likely to rely too much on this sort of improper inference, right? And so it's not, if you look at the cases saying why you can't introduce evidence for this purpose, it's not because it has no conceivable relevance. It's because we have made a decision that this is not a proper, the federal rules have made a decision that this is not a proper argument. And here, the argument, if this is not improper, if there's no remedy for this, it is licensed to any defense lawyer to make this exact argument. We flagged it over and over again. It could not have been more blatant. And I want to go back, obviously the other two issues we have are about the don't relate to what happened at trial. They're about the summary judgment dismissal. And I think in both of those cases, there's clear factual determinations that were made adverse to the plaintiff. It's very clear that the district court can't do that on summary judgment. It's a little tricky here because we've got some things that are appealing from a trial and some things appealing from summary judgment. But at summary judgment, every inference has to be given to the plaintiff. And here, we've got an example of, in particular, with the Pennica and Susi, everyone admits that if you can find as an intentional bad faith suppression of evidence, that the claim has to go forward. And if you can find that they were made aware of the court order, which expressly required them to produce any evidence about Jermac Jones to the plaintiff at that time, that a jury could find that it was an intentional and bad faith suppression, that becomes a question of fact. Here, what the district court held was that the testimony of the ADA, who had this court order and who had an obligation and said it was his practice, although he didn't have a specific memory, it was his practice, obviously, to inform the agencies that he's representing of their obligations under the order. And looking at the record, he believes that's what happened here, even though he doesn't have a specific memory of it. The court held that was insufficient evidence to support a jury finding that that's actually what happened. And the law is very clear that that is proper habit evidence under Rule 406. If you look at any of the cases we cited in the brief, Doe v. Chapman from the 8th Circuit, Gould v. Winstar Communications from the 2nd Circuit, it's crystal clear that that's sufficient evidence to support that. So that on its own was
So
error.
returning Judge King's initial question in terms of what remedy you seek, at least insofar as that particular argument, you are saying you are entitled to a trial, to be simply a trial against those two officers.
Yes, so we want a trial against Susi and Pennica, and we want a trial against the city of Durham on the Monell claim. And it's a similar issue.
You want two trials or one trial? What do you want?
We want our claims reinstated for trial as they should have been against those
Against the
additional
two
defendants.
officers?
The two officers and the city of Durham. Yes.
Do you want two trials or one trial?
I mean, exactly how it's done,
That would be up to the district court.
Right, it would be addressed.
So you
yes.
want to go to trial against the two officers
Yes,
and two other officers of Durham and against the city.
and the ability for a new damages
And the city,
assessment.
the argument about the city has to do with a witness that testified against your client who they didn't disclose that she was a confidential informant,
Yes,
undercover person for the city police.
right.
That was evidence that was actually withheld from the prosecutors too, wasn't it?
It was. There's no dispute that the Durham had substantial evidence that did impeach her testimony, and that none of that was disclosed at the time.
And you'd have to prove that the city was in on it, that they have a policy of not disclosing the confidential informant information to prosecutors?
Right, so what the evidence,
And you're saying that was the policy of the city of Durham, not to disclose the investigative information in the city of police, in the police department, not to disclose to the prosecuting attorney what was going on with the witnesses that he or she was calling to the witness stand.
That was the evidence that, yes, that the city itself put in on summary judgment, was that it was their policy was the reason that this information, again, it's undisputed that they had this information, and it's undisputed it wasn't disclosed. So the only question is, why wasn't it disclosed? And what the city's evidence put on at the time of summary judgment was it was as a result of a city policy.
Have we ever given a trial on a Mandel claim?
Have you ever given a trial on a Monell
ever.
claim? Yeah, I'm sure you,
That's the policy of the city,
right,
to
so,
violate somebody's constitutional rights.
right.
Have we ever approved actually a damages trial against the city for that kind of a claim?
Against the city of Durham or against any
Against
municipality?
anybody? I just don't remember one.
I mean, I'm sure there have been.
That's the policy. Well, sure they have.
Right,
That's-
I mean-
but this Manel's a Supreme Court case, right?
Yes.
Yeah. And it
But-
says it has to be the policy.
I mean, just
It has
for,
to be the policy of
right.
the municipal entity or the government, the right type of government that is, to violate constitutional right.
And if you look at the Monell case law, there are multiple different ways of proving liability, and
Well,
each,
that's what we need to talk about, and Judge King's point. Your question in terms of whether we've done it before, surely the cases all over the country, which Monell policies have been used. I don't think we question that. The question is what is required. It is required that you show that the city itself knew of this policy. What you have here is testimony of a captain who describes the policy. Is there anything else? I mean, how do you take that to say that's the policy of the city?
well, it was the city's, it was a testimony that the city itself, again, put forward in the litigation here. And it wasn't that he came up with this decision. It wasn't the captain's testimony he came up with the decision. It was his testimony that this was the policy of the city of Durham for over 30 years.
But what the law requires is that, and I think what Judge Wynn's getting at and what the district court found is there needs to be evidence that a policy maker, approved or the policy or was aware of the policy. And the district court found that there had been no evidence of that beyond the police captain. And do you have evidence of policymakers within the city of Durham that said, yeah, not just that we keep information about confidential informants, we carefully guard it, but that we do that in a way that violates defendants' constitutional rights?
And answering this question, understand what we're looking for here. It can be an express policy or it can be by custom. But you've got a captain here. And what you don't have is you got to show evidence of a final policy maker of this organized crime unit. So I mean, or whatever is that, whoever is a final maker. It can't be one of the ones, I guess, that, is under there that just says, well, this is the policy. You got to have evidence from that here. It's coming, it's a little bit more concrete than that, don't you think?
So respectfully, with respect to the final policymaker, the cases that the district court was citing, so again, there's multiple different ways of showing Monell liability, and there's a different requirement when you're talking about a single decision, and in that case, you definitely need to show that the single decision is by someone who has final policy-making authority. When you're talking about a policy of the city, you don't look to the policymaker, you look at, is this the policy?
Well, that's more the custom, isn't it? I mean, it's one thing to say you have an express policy, or you can show it's the custom. They've been doing it. Everybody knows you've been doing it. That's different. Which you can get that both ways, but I'm not sure you get there by this single testimony from this captain.
There's alternate ways of, that's true, you could also show a custom, but I think here, the evidence is, again, this is put forward by the city itself as saying the reason that this evidence, this clearly exculpatory evidence was not known to Dowdy, which was what they said. Frankly, we had a hard time believing that could be the case, but that was what their evidence was. The lead detective never learned about this extensive other involvement by this key witness in the case with other cases in the Durham Police Department that clearly undermined her testimony. They said the lead detective never knew, and the reason that we know he didn't know is because this is the policy of the city of Durham to keep this so highly secret that it's not
But isn't
disclosed.
isn't a fair reading of that, we have as I read the testimony, I tried to read it all because it's an important issue. The testimony is generally that, that the police department guards information about confidential informants very carefully. And for, good reason, right, as a general rule. And in this case, which it seemed was unusual, a confidential informant became a witness. I think that, as I read it, that probably doesn't hardly ever happen, because then you get outed and bad things happen, as happened ultimately to this witness. And so it looks to me that when the policy is to guard information carefully about confidential informants, and it struck me as probably rare that those confidential informants end up testifying. And I think that's the problem that the district court honed in on, that we have one example here of a confidential informant that ended up being testified and the information wasn't disclosed. We may have a policy, even if you consider it a policy, even if it's enough to be that talks more broadly, not about a policy that regularly happens of withholding Brady information.
So again, I think that this is looking at what is required in other types of Monell claims and confusing that for the policy claim, or even a custom if the custom is of keeping this information secret. So if you have a claim for a pattern of unconstitutional conduct, like for example, what was the issue in the Owens case, or you have an omission claim where you're saying the city failed to take any reasonably necessary action, then there are different requirements. Here, and I would say also exactly what the policy is, the interpretation of it, those are all questions of fact on this record. So it's just like what the Sixth Circuit addressed in the Jackson v. City of Cleveland case, where there was a dispute. The plaintiff claimed that the policy directed or permitted the withholding of certain types of exculpatory evidence. And the city disputed that. The city said, no, that's not what our policy requires at all. And the Sixth Circuit looked at the varying interpretations and said, there's a question of fact here about exactly what this policy requires, and so therefore this is a jury question. But in a situation where you're talking about the policy, which again, the evidence here is that there's evidence from which a jury could find this was the policy. And again, this is exactly what the city was arguing and what the defendants put forward as their reason why, as their defense for Dowdy, why he didn't know about this information, was that this was the way that this was handled across cases over a period of time.
Is this you said the district, is that, you talking about the prosecutor then or the police officers?
I'm sorry.
Who had the policy?
The city of Durham.
I thought you said district.
If
You didn't say district.
I don't think so.
All right.
I didn't intend to anyway.
All right. So you're saying this is a policy of the police department?
Yes.
And that binds the city?
Yes.
It's not the policy of the district attorney?
No.
You don't claim that?
No. There's no question the district attorney did not know this information or it would have been disclosed. Mm-hmm. So the issue is, and again, the testimony from city officials offered on behalf of the city was that this was the way that things were done consistently over 30 years. So based on that is evidence from which you could find that is actually the policy.
Was that part of the habeas corpus proceeding, this point? This lady testifying and not being and the failure to disclose?
Was that
involved in the collateral proceedings for habeas relief?
So the conviction was vacated based on new evidence, DNA evidence, and other evidence like the information from Jermac Jones.
What was this part of it? That's what I'm asking.
I don't remember whether this was raised. I don't think there was a finding of a Brady.
No, all right.
I can't remember, but the basis was innocence, new evidence suggesting innocence. But in the course of these proceedings, there's been no dispute. Nobody disputes that this information was held by the city of Durham, by the police department, both in files, and that there were people within the city department who knew, or would have known about the witnesses' interaction in both types of cases, that she was a paid confidential informant. There's no dispute that that information was never disclosed. There's no dispute that that was a Brady violation.
All right. Thank you. You've saved some time, and we've given you a lot of extra time already with a lot of questions. Mr. Ellis?
May it please the court, I'm actually Attorney Henry Sappenfield, and to go to Judge Wynn's question.
Well, I had Mr. Ellis down as the second lawyer. I'm sorry.
Well, I was going to say,
And had you down as the fourth lawyer.
well, there's only three, so that makes it even
You got
worse.
promoted, but you don't share it any way you want. I apologize for giving you the wrong name.
No,
You're
Your
not
Honor,
in charge this time. Pardon?
I was just going to say, just to give you a sense of how we had divided it up, our effort was to track the appellant's opening brief. So I was
Okay.
going to address the dismissal of Susie and Pinnica on summary judgment. I was also going to address the pardon of innocence argument made by Dowdy, and then Mr. Ellis was going to address the claims of evidence at trial, and then also the Juror 7 exclusion, which was the second part of our appeal, and then Mr. Gillespie is going to address the defendant, City of Durham's, being dismissed on summary judgment. We're happy to handle this in another
No,
order.
we're going to handle it the way you all want to handle it. So I just, you've made that outline, and you may go forward. But tell me this, who you represent?
I represent, for purposes of what we're arguing here, I'm going to first represent Susie and Pinnica and the granting of summary judgment as to them, and then I will present Defendant Dowdy's argument on appeal that the pardon of innocence was wrongfully admitted.
So you represent all the three officers?
Yes, Your Honor.
Okay.
And, Your Honor, concisely, because it wasn't discussed as much in the opening, Susie and Pinnica were dismissed on summary judgment from the claim that they violated Darrell Howard's due process rights by withholding evidence. And one of the issues that was well briefed to this court was the question of whether or not the 2011 order that instructed information be shared with Mr. Howard's counsel was ever actually received by them. And there was a stipulation in the record that it was not served on the Durham Police Department. And there was the ADA assigned to it, Dale Morrill, who said he had no memory of serving it on them. And Susie and Pinnica both said that they never received it at that time. The argument made under 406 is based upon ADA Morrill's brief statement that that would have been his practice to notify and serve people. Rule 406, evidentiary purposes in the Fourth Circuit, there's not a great deal of discussion. That's the reason why I believe opposing counsel is citing to other circuits, is because there's not a great deal. But I think that there is sufficient reason that Judge Schroeder properly granted summary judgment below. One, because the fact is that they never received it. Two, to say that I had a practice of complying with orders. There's nothing in the order that required them to serve Susie and Pinnica. Mr. Morrill testified, I've never dealt with a post-conviction matter before. Susie and Pinnica testified, I never dealt with a post-conviction matter before. This is terra nova for these people who are doing their best, and they have no memory of ever serving it. There's also the issue that there's no evidence of actual malice. The opposing counsel points to the fact that they are members of the Durham Police Department and that they recognize that it would be embarrassing for the Durham Police Department if there was found to be a wrongful conviction. But they did not know Dowdy or any of the investigators at the time. They were not involved in the investigation. They did not provide any evidence that there was anything indicating that they themselves would have acted out of a desire to withhold evidence. And turning very briefly to the pardon of innocence, I'm sure this court knows there was a decision issued.
On that, the officers did read through those trial transcripts, didn't they?
Captain Pinnica did review the trial transcript because the actual file was not there, and he did tried to determine what his obligations were and what he was expected to do. And he did speak with his supervising officers because he was trying to figure out what to do, in part because the district attorney had said that they were not going to take any action on this matter. So we have to distinguish this between matters that are being actively investigated and, as I said, this Terra Nova, this idea that we are going to, there's post-conviction relief, but the DA is not actively involved in handling that.
What you started to talk about our recent decision, thinking the Brown and McCullum case, that admit or affirm the admission of a pardon, like few days ago, right?
Yes, Your Honor.
I know that wasn't present at the time of trial, but is there something different about this one compared to that one?
There is, and I was relieved to see in our brief, I believe on pages 82 and 83, where we discuss what we believe to be the key factual distinctions between the two. Briefly, in that one, the North Carolina Innocence Inquiry Commission, that is the entity that has the ability to determine innocence in North Carolina, had concluded that there was evidence of innocence in that matter. There was
the other one?
In the other one. It was never presented to the Innocence Inquiry Commission in this matter. There's also the fact that the Innocence Inquiry Commission investigator, there was then a motion for appropriate relief that was submitted, and in that, under that, to a judge, the person who testified was the investigator from the Innocence Inquiry Commission, and then Judge Cooper,
The governor.
then Governor McCory, had all of that information available to him, and that is what he considered. As the panel said on the 8th, that pardon of innocence was basically a recapitulation of what came before. There are the deficiencies that are laid out, again, in our brief as to why this is different. I'm happy to answer more questions about it, but I want to leave time for my co-counsel.
Up to you all.
Thank you, Your Honor. Nick Ellis on behalf of Detective Dowdy. And I want to address two of the issues that are on appeal before the court at this time. The first is going to be the plaintiff's appeal concerning their contention that the trial court erroneously admitted evidence in violation of 404B. The second issue would be Detective Dowdy's appeal as to the court's declination to grant a motion to strike for cause juror number 7. So first of all, as far as the appeal concerning the admission of evidence that the plaintiff believes was improperly admitted, and they talk about 404B, and they cite cases that are 1983 cases that address 404B, which are completely different from the case presented to the district court. As the court knows, 404B does not cover evidence that is intrinsic to the underlying crime, event, incident. And that is what the trial court did in this case in a very, very extensive motion in limiting hearing, briefing, and analysis by the court. It determined that the evidence of the plaintiff's drug use, the evidence of his working or being a drug dealer, and also the evidence of the numerous trespass arrests that had been made of him for being in Few Gardens in violation of the local ordinance, that all of that evidence was intrinsically intertwined with the underlying event, which makes sense because what was the underlying event? It was a double homicide in Few Gardens. There were witnesses that had
I think, counsel, that I don't mean to interrupt you, and I appreciate that, and I kind of asked some questions that alluded to how that was the case. It looked like the focus of Mr. Howard's counsel was, even if that's true, when you get to closing argument, you didn't argue it for any of those issues. You made statements that indicated, I say you, it may have been you, it may not be you.
It was me. Yes,
Okay, I'm not criticizing, I'm just trying to get the question out. That, maybe transferred it from issues that might have been intrinsic to things that were improper. And, I'm sure there are other issues, but that was a focal point, that whether or not from a admissibility standpoint, motion in limine standpoint, there were intrinsic issues, damages issues, other things. At closing argument, you they would say, went in a different direction that was improper.
Yes, sir. First of all due respect to the plaintiff representations that have been made in this argument about what was contained in the closing argument at trial, I would rely on the arguments as reflected in the joint appendix.
Okay.
So the jury instructions from the trial court, I'm going to read those verbatim because it's those jury instructions on the issue of damages that, of course, set the parameters for what can be discussed. And in the instructions, the trial court said that you can award damages for pain, suffering, mental anguish, inconvenience, loss of liberty, loss of enjoyment of life. And that the court also instructed the jury that an individual's own testimony, along with the circumstances of his situation, are relevant to the argument and the consideration of damages.
Okay.
So what we have here, their own damages expert witness, Dr. Artigues, had gone in and she had said, when I'm diagnosing this individual and I conclude that he had post-traumatic stress disorder, that the first thing, or one of the things that I do is I consider his full social and developmental history.
So if I could interrupt you a little bit there, because I accept, I think it, I'm not saying how I'd rule, but I can see how the issues that are complained about relate to a damages claim. Maybe it's proper here, maybe it's not. That's not a ruling. But again, I think the question is whether it was argued as damages evidence or whether it was argued as character evidence. Could you address, I think I think it's okay to argue why damages should be a certain amount based on the expert testimony and all that sort of stuff. What is not okay, or at least the argument is it's not okay to say you should. This guy's a bad guy. He's done a bunch of bad stuff. You should rule against him or lower his damages just because he's a bad guy.
Correct. And Judge, evidence introduced by the plaintiff in his own case talked about him selling cocaine from the age of 18. Stealing drugs from the New York Boys, who the plaintiff contended was the actual group that murdered the Washingtons, that he was addicted to drugs, that he had trespassed in a few gardens. All of those things were from the plaintiff. All of those things were relating to his circumstances of his situation. There was an issue about the gunshot incidents, and initially the trial court found there was one incident in 1992 which led to the plaintiff being hospitalized for a month. That was intrinsic to the underlying case because that is when Detective Dowdy interviewed him, was in the hospital. Then when Dr. Artigues began to testify, or shortly before, the court revisited the issue about the relevance and the probative value of the other gunshot incidents, determined that they were admissible because they were being considered by Dr. Artigues, and specifically in the jury instruction said that is solely related to damages. So obviously, arguing about the gunshot incidents was relevant to the consideration
So
of
your
damages.
position is your argument was not to say he was a bad guy. Your position is to say he's seeking damages, this is relevant to damages. Or in certain cases, it was intrinsic to the actual case itself.
That's correct. Sorry, I want to take the remaining time that I have and pivot to Detective Dowdy's appeal as to juror number 7. And on that, and we've articulated and included in the briefing her responses. And as the court knows, and we cited the Wolf case, simply because a juror says that he or she can be fair and impartial, that does not mean that the rest of the information provided by that juror gets washed away. Juror number 7 identified 13 times in her voir dire responses that indicated that she was going to have difficulty being fair to Detective Dowdy.
Do we review this for abuse of discretion?
As far as this, Your Honor, that is correct. It's abuse of discretion. She testified that her significant other had been involved, I believe, in a drug case in federal court, went to court longer than they had expected. Is that going to impact your ability to be fair and impartial? She says possibly. Not no, but possibly, so we're starting there. But then she says she still has feelings about that could play a role in her ability to be a juror. They could have an effect on her on how she sees stuff. She was asked again, can you set aside that experience and decide on the evidence and law that is given by the court? Her answer, honestly, I can't say for sure. Then she goes on to say that in consideration of other events going on at the time, that she had a fear of police, she was fearful for her child, that she does not believe that police are held accountable for their actions, that innocent African-American men in particular are being harmed by law enforcement when they have done no wrong. And that obviously was the claim the plaintiff was making in this case. She stated, and this is what the trial court initially did grant the request to strike her for cause, she had a sour place in her.
But I think when we're dealing with a case like this, it is abuse of discretion, but it's manifest abuse of discretion. We get cases on jury-type issues all the time. And here, repeatedly, Judge Schroeder asked, and she responded, could you be fair and impartial? She said yes. And granted, maybe we would have ruled differently, or there could be difference of opinions on it, but when you add that qualified manifest abuse of discretion, the court is very reticent to do anything with a matter like that.
And Your Honor, understand it's a high bar, and we understand that and appreciate that, but we believe we meet it because of the statements that I've just referenced, and because the court initially granted the motion.
But they have to be looked at in context, don't they?
Yes, sir. You have to look at it in context, but I just want to close with that there was no additional voir dire information provided by the jury when the trial court reversed itself. I think if there had been additional information, we're probably not here. But because of the information that we had, that information was sufficient to have a finding to strike her for cause, with all due respect to the trial court, we do believe that that was a manifest abuse of discretion. And so we would ask that the appeal on that issue for Detective Dowdy be granted, that he be granted a new trial.
And that would have the effect of undermining the verdict for damages.
Yes, sir, that would be starting all over. That would be starting all
And
over.
they partly agree with you. They want a new trial also. But they don't want to get to the liability part of it.
They don't want to have to revisit liability, Your Honor, and I think as far as the plaintiff's appeal, for the reasons we've said today and in our brief, that
What's the
appeal should be
relationship then
denied.
of your issue with their issue? When if your argument was all about damages, and they want a retrial of the damages.
They just want to limit it to damages, Your Honor. They have not cited a single case that supports that position. The only wrongful conviction case that they do cite is one where the evidence of innocence that the plaintiff was attempting to admit was precluded, and the court did find that that prevented the plaintiff from being able to effectively prevent his evidence as to the issue of innocence. That's not here.
Counsel, I hear what you're saying there on that case. Is any of the evidence that is subject to the objections that were made in the appeal, I'll call it just bad acts evidence, I'm not trying to limit it, but does any of that relate to liability at all? Or is it all related to damages?
as far as that, Your Honor, we would contend that it does flow back to that initial liability question, because that, of course, the liability questions was there a fabrication of evidence, concealment of evidence, and then was there an investigation conducted in bad faith? So to contend that, well, that information somehow was to their, if there was an error, it was to their favor, we believe that if there is going to be a restructuring of the case in consideration of what evidence is permitted, that it would require a trial on all issues. And I would defer the remainder of our time to my colleague, Mr. Gillespie. Thank you, Your Honor.
Thank you, Mr. Ellis. Mr. Gillespie,
Good morning, Your Honor.
good to have you with us, sir.
It's good to be here, sir. The district court properly granted summary judgment for the city on plaintiff's Monell claim.
You represent the city of Durham.
Yes, Your Honor, I do. I represent the city of Durham in this case. First of all, there was no policy authorizing non-disclosure of Brady information. The declaration from Captain Kelly that's been discussed, it only addresses measures to protect the safety and security of confidential informants. It's a general practice. It does not state that Brady disclosure is not required. Judge Quattlebaum, I think you focused on that in some of your questions.
Accepting that, though, that would include, it might be broader than, but would include the situation we have here, correct? If accept that as true, if you accept the fact that you guard information about confidential informants as true as we need to do on summary judgment, I know there's competing evidence on that, it would at least include situations where those confidential informants become testifying witnesses.
Yes, but it would not yield to that situation, and that's the point.
What do you mean?
What do you mean now? Yeah, I'm sorry.
Well,
Go ahead.
the obligation, the Brady obligation would trump, if you will.
That's what, I hear you, and the law would require that to be the case. But in this case, it didn't yield. And so is your point, is your point that there's just not other examples where it didn't yield, or there's not an express policy where it's supposed to yield? Tell me what you're talking about.
Both, Your Honor. Both, Your Honor. First of all, as to the first one, that there's not a policy. Paul Martin was the Organized Crime Division commander. At the time, Betty Boswell was, and at the time of the trial. Of course, Betty Boswell was one who supposedly didn't disclose to Dowdy. But Martin, who helped develop the city's rules and procedure, not the city's, police department rules relating to investigations, he testified without contradiction that the disclosure of Brady information was required. He said this at least 5 times. And you'll find these 5 times in the record at JA 393, 394 to 395, 397, 837, and 869. He said over and over again that that disclosure of Brady information was required. So that goes back to my point that the general concept of protecting confidential informants yields to the specific of Brady information is required to be disclosed. That's what
I hear you on there, and I can see how you could put those two together and say they're consistent. But I wonder if on that issue alone, we have, a question of fact about whether it yields. When you have, what we have here, the fact that it didn't yield here. And I wonder if the, more pertinent question is not whether, it is not that, but whether there's not sufficient incidents of, constitutional violations that satisfy the, that would constructively indicate policymakers knew for Monell purposes.
I would agree with that in 2 respects, Your Honor. You're absolutely right. First of all, there is no policymaker involvement in the practice of protecting confidential informants. There's absolutely no evidence of policymaker involvement in that, which is the sine qua non of Monell liability, number one. Number two, as to your point there, Your Honor, there must be a custom and practice which requires a persistent and widespread pattern of constitutional violations. That was stated in the Connick case. In the Connick case where there was a Brady violation, there was only one Brady violation. And the courts have said repeatedly that a single violation is not sufficient.
Is that, if you have, and I know you probably don't agree with this, but if you have a policy approved by a policymaker, a final policymaker, do you agree? I think in that situation, you're not obligated to show a bunch of examples. But if you don't have evidence of a policymaker approving the policy, then there's other ways to get there, as Judge Wynn talked about earlier, and that's when you have to have more widespread examples of constitutional violations.
Yes, Your Honor, that's exactly right. You must either have policymaker involvement or you must have repeated violations. And we don't have either of those in this case. I see I have 30 seconds left. Your Honor, I'd also like to point out in the short time I have remaining that in this case, there must be an underlying constitutional violation to fasten Monell liability. In this case, the only constitutional violation which the plaintiff is trying to lay at the city's doorstep, if you will, is a Brady violation. But in this case, the jury found that there was no Brady violation. So we don't have an underlying constitutional violation that is necessary for a Monell claim, as the Supreme Court has said in City of Los Angeles
When did
versus...
the jury find there was no Monell violation?
Your Honor?
No Brady violation?
Yes, Your Honor. I'm sorry, I didn't hear your
When did
question.
the jury find there was no Brady violation? Was there an interrogatory?
Yes, Your Honor. It's the second issue. It's on page JA 3571. JA 3571, the three issues presented to the jury. The second one...
Is that the verdict form?
Yes, Your Honor. The jury verdict, they found there was fabrication, they found there was a bad faith failure to investigate, but they said no on the issue of suppression of evidence. Therefore, there's no underlying constitutional violation, and thus there can be no Monell liability because the only issue in the plaintiff's appeal as to which they seek to hold the city liable is the alleged Brady violation. I'm out of time, Your Honors. Thank you.
Thank you, Mr. Gillespie. Appreciate it.
Starting with that,
Ms. Hoffman?
that's incorrect. The jury did not find that there was no Brady violation. There was no dispute that there was a Brady violation. The issue at trial, which was only against defendant Dowdy, was whether Dowdy himself knew of the exculpatory information and was responsible for suppressing it, or whether it was other members of the DPD. And Dowdy's defense, which is consistent with what was presented at summary judgment, was that he never learned about this because of this DPD policy, which kept it absolutely secret. And so there was never any dispute, and the court already found on summary judgment.
What was that jury verdict?
That was on whether Dowdy himself was responsible for the Brady suppression. That was the question. And his argument was, I never knew about it.
Responsibility.
Yes. And so if consistent with that, the question is, why was this Brady material, this clear Brady material, which there was no dispute should have been disclosed, not disclosed? And the evidence was, and a jury could find, it's because of a DPD policy. Also, you could find liability either on policy with an inference that given the testimony and the information, the jury could infer that this was a policy that was officially adopted. Again, a policy can be spoken or written. Factual question was something that they testify applied for over 30 years, whether that was an official policy. You can also find it was a custom. The custom does not need to be of unconstitutional conduct. It needs to be a custom that is so widespread that you can infer constructive knowledge by the policymakers. Again, their own testimony is that this is the custom. And in this case, what you're talking about when you apply the custom, which, by the way, there is no official policy of Brady compliance. So if you compare it, for example, to the Jackson v. City of Cleveland case, they were looking at a policy that said, yes, you have to turn over Brady material, but maybe there's an exception for this one category, and a jury could interpret that to say that that's permitting Brady violations. In this case, we have the policy of keeping this information absolutely secret. There's no question that in a circumstance where the confidential informant is testifying, if you keep this absolutely secret, that is going to be a Brady violation in that case.
Do you have other examples where that occurred?
So the only evidence we have is that there were multiple cases in which this same witness was testifying, and there's no indication in any of those files that this information was disclosed. Although I will say we had very limited discovery into understandably who other confidential informants were. So we don't know, because we weren't even told their names because of the secrecy, who else there might have been and whether there were other violations. The only discovery we got is as to this one informant who was involved in this case. On the Susie and Penica issue, there's no question the review is de novo on the denial of a summary judgment. Same with the Monell question. And so these are fact questions for a jury to resolve. If there's disputes of fact that implicate whether there's liability, then those claims have to go forward to the jury. On the damages issue, I would urge the court to look exactly at the specific words that were spoken in closing and the specific words that were spoken to the court in defense of this argument. Specifically, what are his damages? Everybody has personal choices to make. Everybody then has to deal with the consequences of the choices they make. Specific comparison at the beginning of opening, in closing. Look at the choices that Daryl Dowdy made, the defendant in this case, and all these wonderful decisions he made. Look at the choices that Daryl Howard made in his case. That's what you should be thinking about on damages. We have it, it's in the record, it's also long quotation in our brief, specifically talking about the times that he was shot, which again, the stipulation was, because the evidence supported that that Mr. Howard was a victim. He was an unfortunate victim of gun shootings. And we sought to keep that evidence out because of the risk that the jury would infer criminality and violent nature based on the fact that he was a victim. And they said, we're introducing this evidence for a different purpose, the judge accepted it. Then you get to closing argument. He admits that he was ambushed, shot on 5 different occasions, shot a total of 11 times. Those are decisions that Mr. Howard made as far as how he was going to live his life. This is an express character argument. It was absolutely improper. It was never corrected. And the standard is, and again, we're not saying that the verdict is insufficient as a matter of law. We're saying that the argument is improper. It was not corrected in any way. And under the standard, you cannot have confidence that this error did not substantially affect the verdict. And in particular, if you compare to other damages verdicts that are entered in similar cases, this verdict is far lower than the typical verdict you would get. And you can't say, it's possible he would have gotten that lower verdict anyway for 21 and a half years that he spent wrongly incarcerated for crimes of which he was absolutely innocent. But the problem here is when you have this improper argument and there's no instruction by the court to that this you could not consider, and there's no way for a jury to know, they're not lawyers, that character evidence is improper or that propensity argument is improper if the court doesn't tell them. He did not say anything about that. He just said you can consider this evidence on damages. You cannot have confidence that that did not affect the verdict here. In terms of whether this affects the liability or damages trial, we cited 2 cases, Parish v. City of Elkhart, which is exactly this circumstance, improper evidentiary decision in a wrongful conviction case. There's no question it didn't have an impact on the liability finding because it was an error against the plaintiff and the plaintiff won. They are remanded solely for a new damages trial. We also cited a case from the 4th Circuit, I think it's Sasaki, in which the similar issue, it was not a wrongful conviction case, but they said there's improper argument, it affected damages only, and so the remedy is to remand for a damages only trial because there's no evidence that it impacted the liability decision. So that's the appropriate remedy. That's what we're seeking here.
Thank you, Ms. Hoffman.
Thank you.
We'll come down and greet counsel, and then we'll go to the next case. In our fourth case today, we have Mr. De La O et al. Versus the Attorney General Garland. Mr. Ritchie,
Good afternoon, Your Honor.
good to have you with us, Mr. Ritchie.
Thank you. Good to be here.
You may proceed.
Thank you. May it please the court, my name is Ronald D. Ritchie. I'm here on behalf of the petitioners. The petitioners in this case did establish the nexus to the harm or persecution that they suffered due to their family membership. The first thing that they suffered is when the lead petitioner, I'll call him the father, because there's a father and son here in this case. The father went with his brother Josue to meet with the gang. MS-13 had requested they meet. They went and met, and the gang forced them to take off their clothes to check to see if they had the other gang's tattoos or any kind of marks on their body, and threatened them to not do certain things.
You have an argument here that the agency mischaracterized this particular social group. And it's kind of hard to follow because when I look at the transcript of what was actually said in the formulation of understanding this group, it looks like to me counsel got a lot of help from the IJ on it in terms of formulating this group. And so ultimately what was agreed upon or set forth, the counsel for your client basically designated this as the group. So why should we now look behind that and say, no, this is a mischaracterization?
Yes, Your Honor. Judge Wynn, in this case, well, I think we get some guidance from the Quintero case, wherein this court held that the Refugee Act is to be applied by, and there's supposed to be guidance, and it's really a joint concerted effort, if you will. The judge, counsel, if there is counsel for the asylum applicant, and the DHS attorney. They should work together to try to come up with a PSG, particular social group that's cognizable. In this case, the counsel for the petitioners put forth at least two particular social groups we believe are cognizable. The first one being familial relationship, and the second one relationship with his brother, that's pertaining to, of course, the lead petitioner. The judge then further questioned that and stated that he didn't believe that would be cognizable, claimed that it was circular, and so then it came to the third PSG of the family members of those persecuted by gang members. Then before the board, a similar PSG was put forward, familiar relationship to petitioner's brother, again relating to the lead petitioner. The board has held that it can consider PSGs that they're slightly different. If they're a variation of what was put forth before, as long as the facts are similar and the facts would support any of those PSGs, and they're not substantially different.
So, counsel, let's just, for the sake of discussion, say that there was something that was wrong done with the identification of the group. And let's say, for the sake of discussion, there was an error on the nexus. For asylum and withholding, you have to show that the government is unable or unwilling to control in a way that avoids the persecution. And for CAT, you got to show government acquiescence. And both that, and the BIA lists a number of facts that, it relied on to show that requirement, which is a requirement independent of the other issues, wasn't met. He talked about how your client stayed in another city in El Salvador for about 3 weeks without incident. Talks about how other family members remained in El Salvador after your client left the country without being harmed. Even if we were to agree with you on the other grounds, how is that an error that we could, remand? And isn't that an independent basis for denying the petition?
It could be an independent one, yes, Your Honor, because it's a separate issue. But our position is that in this case, there was past persecution to the petitioners, and therefore the burden would shift to the government to show there's been a change in country conditions such that they could return
Or that you
safe.
could relocate somewhere safely, and the agency found that was the case based on the fact that your client moved to a different area and remained there, without incident. We get these cases, and lots of times people try to leave, and the gangs are following them and threaten them, and they can't. But we don't have any of that here, so the agency made that finding. Why? I mean, I get it. The burden may shift, but why is that not proper to say they satisfied it?
Well, for at least two reasons, Your Honor. Excuse me. One is petitioners moved, relocated, if you will, and they were only at that new place for a few days. I believe it was less than 10 days. Excuse me.
The BIA says about 3 weeks.
I believe that the testimony says something different, Your Honor, but I could be wrong on that.
And you may be right on that. I don't know.
Excuse me. So that would be one argument, is that a brief time of not being killed or harmed by the gangs is not sufficient time, even 30 days, because the gangs, they coordinate, they cooperate throughout the country of El Salvador. They're throughout their countrywide, and so it's understandable, it's reasonable that they can't, contact another one of their partners in crime, if you will, in some other location within 30 days. It may take them a few months. And this court has held in a case precedent that if a person goes and they're, even if they're a few months, maybe even longer in their country, and they're in hiding, which we believe was the case here, then that's not sufficient for the government to say, okay, well then it's safe for you. I would note that the government is arguing that you raised, the CAT claim. They're arguing, well, they moved for a few days to another location, nothing happened to them. And then the BI stated, oh, look, you have the government of El Salvador has taken a few steps. Okay, they've set up some laws to go after the gang members. They've set up apparatus. But setting up, establishing laws, setting up an apparatus is not equate to taking actual action to be able to protect individuals that the government has a responsibility to protect. It has a right, it has an obligation to protect its citizens.
Isn't that inconsistent with acquiescence?
No.
So setting up procedures to protect people from gangs is not inconsistent with acquiescence?
Well, that shows that the government is taking steps. So it would be, Your Honor, but that's why we have also in the standard, if the government is turning a blind eye, okay, to what's going on. And we would argue that there's, if you will, two components to that. One is what steps is the government taking? Is it taking realistic, reasonable steps to try to prevent that from happening? Or is it, or because, as the testimony and the objective evidence showed, that you have a lot of corruption within the ranks in the government and the police force in El Salvador. And the lead petitioner testified that he had even heard or seen on the news about how the gang members and the police were sometimes involved together in El Salvador. So the government is turning a blind eye, okay? It's consenting, it's allowing this activity to go on, this gang activity, if it's not taking concrete, reasonable steps to prevent this gang criminal activity to continue. And we don't believe that the evidence supports the agency's analysis and decision in this regard. I would note that this case does have similarities to the Crispin case, not only because of the nexus, but also the family-based component. And there's also, there's a Hernandez Avalos v. Lynch case, and the Arita Darius versus Wilkinson, and the Portillo Flores cases that we believe are similar to this case, and that one central reason why the petitioners were threatened and harmed was due to their familiar relationship. There's also the component, there's opposition to the gangs, as the lead petitioner had told the gang members, hey, leave my brother alone, stop trying to force him to join, and the gang was not happy with that. And that's why they took the actions that they did, to kill the lead petitioner's brother, to then after, and this goes back to Your Honor Quattlebaum's question about, well, they moved to another area. Well, much of the harm took place after the death of the brother, Josue. The threats from the gang to the family, they happened after that. So that's why we believe that those facts support the petitioner's claim. And the gang said to a sister of the lead petitioner who was in the United States, contacted her and told her, hey, if your family doesn't do what we're telling you that you need to do, demand to do, you're going to continue crying, which was implicit that they were crying in the morning because of the loss of Josue, their family member. And, they're next. This is similar again to the Crispin case in that regard. I will sit unless there's further questions and for rebuttal. Thank you.
Thank you very much. Ms. McKinney?
Yes, good morning. May it please the court. I represent the Attorney General Merrick Garland in this matter. Your Honors, this petition for review should be denied. Petitioners' proposed particular social group, family members of those persecuted by gangs, is not cognizable as they conceded before the board. This group is circularly defined by the harm. It therefore does not meet the anti-circularity requirement identified by the board in matter of WGR and cited by this court in Amaya. This requirement assures that the nexus requirement is kept separate. Therefore, this group is not cognizable. Second, the agency correctly declined to consider a new group proposed on appeal to the board, family relationship to petitioner's brother.
Did the petition initially state a particular proposed social group based on family status?
There's an entire exchange that goes on for about 3 pages in the record, which reflects the immigration judge's attempts to get petitioner's counsel to exactly delineate the group. And that's a requirement for particular social groups. That's been long recognized by the board in matter of AT, which is in 2009, and then again in WYC and HOB. And that was discussed at length also in this court's Amaya decision, There's a requirement that before the judge, you have to exactly delineate your proposed group. And this exchange that goes on for at least 3 pages, it shows the judge's attempts to get petitioner's counsel to identify that group so the judge knows what group the judge is considering, both in terms of cognizability, but also everything else in the record, that you're identifying appropriate facts for this group to analyze it.
Counsel, I mean, it's an interesting kind of exchange. I've spent some time with it, and you know, it doesn't look like the judge, immigration judge, is trying to, you know, coerce or move it in any direction. I think Judge Wynn's right. The initial thing they said was family members of, you know, I think the cousin, I don't remember. And then he says, you know, is that your group? And the counsel, you know, seems to, you know, change. It's just kind of an odd situation where they said one thing and with really out of insinuation that what you did before might be wrong or problematic, they go to one that's worse for them.
So, Your Honor, I would agree that there was no insinuation on the judge's part that the prior group was wrong or that it was a prior group. If you look at the exchange, the immigration judge is asking, so how would you articulate your group? And the response is he was persecuted on account of his relationship with his brother, which that's essentially listing the requirements of the INA. And the judge's response was, well, that goes to the facts. We go to nexus. And then the judge says, but how are you specifically formulating your group? And then the judge asks, do you mean family members of whatever the name of the brother is? So the judge specifically asks, is that your group?
Right.
So I know what group to analyze.
It's rather confusing, but even if you go there, accept that is the group, you have the issues of nexus that's there and other issues in the case too. Why don't you speak to those?
Speak to nexus, yes. So should the court reach the nexus issue, because cognizability is dispositive of asylum withholding, nexus is as well. So the court can also go to that issue, should go to that issue. And in this case, the government argues that substantial evidence supports the conclusion that the petitioners did not establish a nexus to a protected ground. And the government acknowledges and did acknowledge it in the response brief that there are several cases from this court where this court has found a nexus to a family-based social group. Those cases would be Hernandez, Arita, Portillo. And the government is arguing that this case, the facts are distinguishable for several reasons. Here, the petitioners, neither petitioner were directly threatened, and that's something that existed in those other cases cited in the government's brief, direct threats. In all of those cases, there was some sort of tie to the family relationship. Here, the 2 calls to the family members didn't specifically reference the family relationship, so that would distinguish it from, for example,
But that's who they call.
They called a family member. They didn't specifically reference
They didn't say, I'm calling you because you're the family member, but I mean, that's a kind of fine line, isn't it? I mean, they could have called anyone else. They didn't call, there's no evidence they called, you know, neighbors, and these two. The only people that they called were family members, and you can say what you will about our nexus requirements. It's a pretty, you know, it's a fairly lenient way of showing nexus, as we've, you know, put out in many cases. I mean, some of which I may have disagreed with, but that's our law, and we're bound by it.
So in response to that, I would point to the Hernandez case, and there were multiple, I think there were 3 instances of threats made. And the court was distinguishing, even though they were made to the same person, which was the mother of her son that the gangs were attempting to recruit, there was a separate instance in that case also where I believe it was a cousin who had been murdered, and the applicant there had also identified the body there. And the court made a distinction between the 2 calls that were specifically referencing the son and recruitment, and dropped a footnote in that case that it might be different if the court was dealing solely with a different call that had to pertain with the status of that individual, that 3rd threat didn't reference the family ties. And so that would distinguish it from, for example, Portillo, There, the applicant had been beaten, and at each beating, they were referencing the family member. In Aritas, in that case, it was threats that the case concerned. And there, the written threats referenced the family member and again tied it to efforts to get, in that case, it was the husband, the family member was the husband, to come back to the home country. So the government would argue that in this case, the facts are different with respect to nexus. They weren't direct threats. They don't specifically mention the family relationship. And the third reason that would distinguish it in this case would be that we have similarly situated family members who presumably would belong to the proposed social group, also family members of the brother Josue, that are that remain in the home country safely, specifically noting the father, for example, that remains in San Salvador. And when asked during the proceedings if the father had been approached, harmed, or threatened, and the answer was no. So the government would argue that with respect to nexus, those facts distinguish this case, and that even if this court perhaps, when looking at it themselves, if they were the fact finder, that maybe perhaps you might go one way or the other, but certainly the evidence isn't compelling a conclusion of nexus here. Additionally, and I think this is something that Judge Quattlebaum already noted, that we have a separate additional determination regarding relocation and the ability to relocate. In this case, the petitioners would have to show that it would be unreasonable for them to relocate, which they did for 3 weeks safely prior to leaving their homeland, and similarly situated family members have been able to do. I noticed that there was somewhat of a discrepancy, I guess, with the testimony that it was a few days. The 3 weeks that I do think is what the board is citing comes from the affidavit that says we left on, I believe, March 18th, which would have been a little more than 3 weeks, I think, from I believe that the death certificate of the brother is dated from February, I believe, end of February, so that 3 weeks plus or minus. And March 18th is also the date cited by the immigration judge. So the government would urge the court to affirm the agency's denial of asylum and withholding on those bases. Turning to cat protection, this court should also affirm the denial of cat protection because the record doesn't compel the conclusion that petitioners more likely than not will face torture if returned to their homeland by or with government acquiescence. In this case, the record reflects that neither the petitioners nor their family members reported the extortionist threats to the police. And while they correctly note that they're not required to in order to show willful blindness, they still must show government acquiescence. So it's one component of the evidence in this record. Secondly, with respect to the assertion that the authorities would be willfully blind to threats or violence, the petitioner's own experiences contradict that here. Here on this record, the petitioner was twice arrested when he was accused in 2005 of threatening a neighbor. He was arrested and released, so the authorities...
How does that, I read that, how does, I mean, what the claim here is that they're gang members who are persecuting, and the issue here is whether gang members are essentially allowed to run wild in this country. The claim is not that all all law enforcement is suspended. And as I understand it, his criminal activity and the charges that he faced from that didn't have anything to do with gangs. So I didn't really see how that related here.
So I do believe that when the board is referencing that, they're referencing an argument made in the brief to the board that the authorities were not responsive to claims of crime and violence. So it is responsive to that. I believe that the allegation in 2005 was threats, and the 2011 allegation was actually a murder allegation. So the board's statement of that was just showing that the authorities were responsive to allegations of crime and violence. But I do take the point that this might be different if we need to hone in onto the issue, would the government be willfully blind to gang violence? But we do have a response to that from the agency as well. As the immigration judge noted, the authorities had taken action to address gang violence. The president had authorized the use of military force. in conjunction with the police to address gang violence. The second example cited by the immigration judge was the creation of a fast reaction force between the police and the military to deal with violence, including gang violence. Just wanted to add to that, reading the country reports here, I also note the crime and safety reports at page 119 in the record also note that the country has established an anti-extortion task force. So that would be relevant here. I mean, although acknowledging that wasn't cited as one of the two examples that the immigration judge did, but it's just additional, looking at the record as a whole, additional evidence that the Salvadoran authorities wouldn't be willfully blind in this instance to gang violence. So unless the court has further questions, the government would request that the court deny the petition for review.
Thank you very much, Ms. McKinney. We appreciate it. Mr. Ritchie?
Thank you. Just briefly, this court reviews the element of nexus de novo. And that's found in several cases, including Perez Vasquez and Cruz versus Sessions. It's difficult for me to comprehend how the government can say there's not direct threats to the petitioners. And as Judge Quattlebaum pointed out, I mean, these calls were not made to neighbors or people down the street or some other place. They were made directly to the family members, and for example, one was the sister of the lead petitioner who was in the United States. So the gang knew all about this family. The gang had grown up in the same area as this family. They knew him. They knew the lead petitioner when he came with his brother Josue to meet with the gangs. Gangs were aware of this family. They were aware of the family members. That's how, they're able. The gang is able to reach out its tentacles, if you will, all the way to the United States to contact the sister and threaten the family. The government talks about, well, there's evidence, the record about that the government of El Salvador is saying up, the military is getting involved and this and that, but there's nothing to show that the government is taking steps to stop or reduce, at least reduce corruption and impunity within the ranks of the police force in El Salvador, among others. And so that's significant when it comes to, does the government turn a blind eye to the corruption and the fact that its police officers act with impunity and that they cooperate with the gangs. And therefore, the government, we believe that we have demonstrated that the government does turn a blind eye to what's going on with the gangs. And also about, again, and this has already been pointed out by your honors, that whatever issues the lead petitioner had with the police in El Salvador had nothing to do with the gangs. He was never charged with being a member of the gangs. He was not arrested for that. So, if the government is going and arresting people and detaining them for months, I think he was detained like 6 months and then charges were all dismissed. That doesn't show that the government's going after gang members, because that's what the issue is here, gang members. That's who threatened the petitioners. Unless there's any further questions, I will have a seat.
Thank you very much, Mr. Ritchie.
Thank you.
We appreciate it. We'll come down and greet counsel. Before that, the clerk will adjourn court. Sine die.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.